What kind of host would I be if I didn't say good evening, good evening, good evening, ladies and gentlemen? I am your lone wolf Oozle. And yes, it is true. We are actually live on a weeknight. Ooh, it's unthinkable. It's been done. We're here. We have a smorgasbord of crazy on board for tonight, ladies and gentlemen. We're going to start with Thurston County, Washington PPOs. And ladies and gentlemen, it was a good day in the PPO circuit. It was a good day. I'll just let you see what we have in store. Then we're going to move on back into Michigan, where we spend a lot of our time. We're going to hang out with Judge Dad, who has quite a few things to get off his chest, a few people to talk to. You know how dads are. You get disappointed a lot. That's the way things are. And then we're going to move on to St. Joseph County with Judge Middleton. Because Judge Middleton and Judge Middleton's stories are some of the best in the business. And ladies and gentlemen, we're going to spend a majority of our time tonight with Judge Middleton with a sentencing docket that he had today that all I can call is super interesting. And yes, Chalky is here, ladies and gentlemen. Chalky is live. And we're all gonna get into it. Because you know what? It all starts right now.
Christopher Dula, Anthony DiFrancia. Foster, good morning.
Good morning, Your Honor.
And Mr. DiFrancia and Mr. Dula, please stand, please. Mr. DiFrancia, there we go. Both raise your right hands. Maybe seated. All right. I've read the petition in this case. Are you divorced at this point or still going through the process?
Still going through the process, Your Honor.
All right. And Mr. DiFrancia is with your wife, is that right?
That is correct, Your Honor.
Okay. And he's been posting things online and putting up flyers that one wouldn't like to see.
And more than that, Your Honor.
Okay. Tell me about the more than that.
He has also created 3 websites, ChristopherDula.com, ChristopherWDula.com, and ChristopherDula.com. Mm-hmm. That link to derogatory and defaming material about myself, and Mr. DiFrancia has no consent of mine to be able to use my name for these purposes either.
Okay. All right. Does he contact you at all?
He contacted me, I believe it was on September 11th, with a text message linking to these materials. That was the only time he contacted me.
Before I hear from Mr. DiFrancia, is that how you say it?
DiFrancia, sir, yes.
DiFrancia, okay. So I've read what he said, and he's indicated he has no intent of backing down. He's going to say what he wants to say and tell the world what he wants to say. So I understand generally where he's coming from. Mr. Foster, your thoughts as to whether this is the appropriate way to put a stop to it, or whether there needs to be a defamation action or some other action in Superior Court and an injunction.
That is an option for civil relief, maybe a monetary sanctions eventually, but he's got to stop this action that's going on now. There's no sense to it, Your Honor.
Okay, but my question would be, what's the court's authority to tell somebody not to say something negative about somebody else? We have to obviously.
They're untruths. They're
Okay.
vicious, scamming, nasty.
Yeah, right. I read
to ridicule him.
them. Yeah, how do I get around the First Amendment and the ability of anybody to say really nasty, untruth, false things about somebody.
Well, I am not a constitutional expert on the First Amendment, Your Honor. I know that you, from law school, you have heard the same example that I'm about to say, so you can't stand up in the middle of a theater and yell fire. There's limits.
There are limits.
Under the definition of the statutory definition, I believe he comes in within that relief. The defendant has not an absolute right to say whatever he wants to say about any one person in particular, and in particular, my client. He does not have that right. And there's no reason for him to be launching this vicious attack on my client. None. He's vented. He believes that he has to do this. And it's injuring. Now the signs are his neighbors at the family home where the wife and 3 kids live. Now the sign that you saw on the telephone post is now in front of the house where the 3 children, 5, 8, and 13 live, telling their father that he is some kind of a horrible person to stay away from. There's just there's no reason for this at all. Oh, and as far as civil, yes, Your Honor, he does plan on pursuing the civil rights, the civil relief from this, but this has got to stop now.
All right, well.
Denying the motion is just going to give Mr. DeFranci a license to become more vicious.
After I read the pleadings that were filed in this case last week, I've seen cases like this before, and it always strikes me that I can't believe somebody spends so much of their personal time engaged in in a vendetta against somebody else. To me, it seems like such a waste of time. And Mr. DeFrancia's obstinance and continuingness after having plenty of opportunity to make his point. In fact, he continues to rails, sort of like bang at the moon, telling it not to come up, knowing it's always going to come up. So it just, personally, yeah, I thought that's really dumb. But I can't order him not to do what I consider to be really dumb. And if he wants to tell the world that he thinks Mr. Drury is a bad guy for purposes of a harassment order, he can do that. Now, Mr. Foster's concerned that this gives Mr. DeFrancia permission to accelerate. I hope you don't take that, because Mr. Dula has the right, and it sounds like he and Mr. Foster are talking about suing you in Superior Court for statements you've made and then seeking monetary damages. And I suspect that would hurt a lot more than me telling you to stop it. So I wouldn't be surprised if you continue on in this fashion, that's exactly what happens. And if I were Mr. Dula, I wouldn't want somebody out there yelling that about me, but this isn't the matter. This isn't the means in which he can effectuate forcing you to stop. I would point out, you have a lot of at risk here. Whatever income you have and whatever assets you have may be taxed if Mr. Dula is successful in getting a court to both enjoin you and then issue a punitive sanction for what you seemingly continue to do. So I would encourage you to stop, but I'm not going to order you to stop. I don't think I have the authority under the statute to do that. So I've signed a denial order. The harassment order won't be a way to address this without any indication that Mr. DeFrancia has direct contact with Mr. Dula or threatening him in any way. He's just saying really nasty things about him. Right, we'll give Mr. Dula a copy of the order that I've signed. This procedure is concluded, and I've dismissed the petition. I'll leave it at what I've already said. Okay.
Thank you.
All right, Mr. Gunstone, Ms. Loy, activate your audio videos, please. Or Ms. Gunstone, I'm sorry. If you both raise your right hands for me. You swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
All right, Ms. Gunstone, you previously had an order against Ms. Loy, and then you find her coming to the Evergreen Community Church that you were at, and you were surprised by that. Is that right?
Not, so I've had two. I've had one for a year that was granted. After that one expired, she came to my church where I was granted another one, which is not expired until February. And she still continues to come to my church.
Right. So the first time was, I think you'd said you had changed churches. Is that right?
Yes, I changed churches. We both went to Living Water together, actually. I had left that home church because it was my home church for many years, but I left it. She was supposed to, I just thought would stay at that church. I had been a member ever since for years now at Evergreen. So I have no idea why she continues to cause issues.
Okay. So when you joined Evergreen Community Church, my assumption, I don't think you directly stated it, was that Ms. Loy was not a congregant there.
No.
And then she showed up at some later time after you were there.
Yes, on two separate occasions. So I think there's a little confusion. I was granted the second order at the church. She was actually served at the church. And then she come back, even though there is an active restraining order currently that isn't expired until February.
Okay. And your concern was the second order that was entered did not indicate that she was prohibited from going to the church.
Yes, she likes to say that she can come as long as she doesn't see me.
I'm sorry, say that again.
I believe in her mind, she thinks it's okay to come to the church as long as she doesn't visually see me.
How do you get to your church?
I drive.
Ms. Loy, anything you want to say?
Yeah, I did think that if I didn't see her, it would be fine. The first time, I did go to both. I was going back and forth to both. And then I moved in this area on the west side, so that one was just closer. And I haven't tried reaching out to Jamie in years. And if she doesn't want to talk to me, I want to respect that. And if she doesn't want me, I did think like I was served the protection order back in February or whenever she had it served at church. I've still been going there since, and I haven't had a problem until I just went last Sunday, and I was at the very front. I had no clue she was there. But if she doesn't want me to go there, I will respect that and I won't go back there.
Okay, thank you.
It makes me feel uncomfortable. It makes her uncomfortable. I could go to any church in the area, and I mean that. I don't, if she doesn't feel comfortable with me going there, I don't want to cause her that stress or that anxiety, and I will not go there. I will respect that. I can watch it online, and there's several other churches I can attend.
All right, thank you.
But also I wanted to say, like, I didn't know she was going there. Like, I had also the first time we went for like the family thing with the kids and the Chipotle, I was at work and I got a text on my phone inviting me to the thing. Like, and then she was there, and then we're at the end of the hallway and people kept pointing. I didn't know there was a room right there. People kept pointing, oh, it's gonna be over there, it's gonna be over there. And I saw Jamie walk out and my kids wanted to say hi to her, but I kind of stayed behind. And I was like, is there another building in the back that we're gonna be at? And then I felt dumb when I did walk around the building. I was like, oh, I guess there's not another building back here. Oh my gosh, I feel so stupid. So I can see why Jamie thought I was following her. But, so I want to apologize for that. And I don't ever want her to feel like she's not respected and she's not safe.
Thank you. And it's called Evergreen Community Church, is that right? Ms. Gunstone?
Evergreen Christian Community.
Okay, thank you. All right, Ms. Loy, I have granted Ms. Gunstone's request to amend the existing order, and I've now indicated that the amendment is that you are not to be on the property of Evergreen Christian Community Church.
Okay. And is that like a forever thing or?
That's while the order is in existence, and the order is currently in existence, I think,
Okay.
until February.
Okay.
I'll also remind you that in that order, it says you have to stay 1,000 feet away from Ms. Gunstone, also 1,000 feet away from her vehicle. So if she's driving to church, obviously that means you can't be at that church.
Yeah, that's fine. Okay.
Okay. All right. I've entered that order, that amendment, and the order is in the file. Both of you can get a copy of it if you wish.
Okay.
All right. Thank you.
Have a good day.
Thank you. Bye-bye. Jamie Shearer, Tina Paz.
Yes, Your Honor.
All right, I'm the one who issued the temporary protection order in this case based on allegations that Ms. Paz drove her vehicle towards Ms. Shearer and some other people and then made them jump out of the way and circled around them. And I believe I read that there is an active investigation. I believe I don't know if Sheriff's Office or Olympia Police was called, Ms. Shearer, which one?
What was your question?
What law enforcement agency responded?
Lacey. I
Okay.
spoke to Sergeant.
And is there an ongoing investigation? Has it been
Oh
closed?
yeah, they were going to send it to the prosecutor's office because I already have a protection order against her daughter for an assault.
Right.
And
do
they
you
were
know
going to
if
let the prosecutor decide what to do in this matter.
Okay. Do you know if that's happened?
I know that they sent it to the prosecutor. I have not spoke with the prosecutor yet. They said that they were sending it to the prosecutor, and if the prosecutor found it a violation of the protection order, they would have a warrant out for Alana's arrest.
All right. But right now we're talking not about Ms. Woodward. We're talking about Ms. Paz.
No, I know. I'm just telling you that's all I know about that.
May I
And
speak, Your Honor?
the investigation, the police investigation involved Ms. Paz or Ms. Woodward or both?
The police investigation that showed up on the scene said that he understood I could not see them in the middle of the road because of the darkness. It wasn't until I saw them with my headlights I was able to see them.
Okay, yeah. That's not my question. My question, Ms. Shearer, is your understanding as to the referral to the prosecutor's office was concerning Ms. Paz or concerning Ms. Woodward?
I think both. I'm not really sure.
Okay. All right. Well, since I'm going to take these one at a time for Ms. Paz, since you're before me now, and Ms. Woodward, if you come when I ask you to participate, there is the possibility that the matter may be at the Lacey prosecutor's office for consideration. And I will indicate to each of you that you have been, and for Ms. Paz now, I've placed you under oath. Anything you say could be used against you in a criminal prosecution. And if you were to have an attorney with you right now, since there is the possibility of a criminal prosecution, I don't see a charge yet having been filed. But if there is the possibility of a criminal prosecution, I'm quite confident that an attorney would tell you, do not say anything.
Okay.
Because you run the risk of hurting your interests if a criminal charge is ultimately filed. So for right now, since it's Ms. Paz that's before me, Ms. Paz, you understand that?
Yes, Your Honor.
And do you have any question about that?
No, Your Honor.
Okay, I'm not telling you can't say something. I'm letting you know that given what I've been told, there is the possibility at least of a criminal charge, and you would run great risk if you say anything at all.
Okay, my intent, all I know is my intent was not to run anybody over. I pulled in, I thought I saw my daughter by the mailbox. I went to go to loop around, and as I was looping, I noticed there were people in the middle of the road. It was pitch black. Was not my intention. I didn't even know Jamie was in the road until I parked my car. and hurt her. So my
You're-
intention was not to hurt anybody.
Your Honor, may I say something?
Briefly, Ms. Shearer.
Okay. The speed limit is 5 miles per hour and it's posted all through the complex. She should not have even been driving 20 or 30 miles an hour towards anybody to begin
Okay.
with.
And did Ms. Paz say anything to you upon exiting the car?
Yep. I said, that's Alana's mom. She goes, yep, sure is. Just
I
like
don't,
that. That happened, I swear.
I don't recall that.
Of course you don't.
Okay. Okay. I don't want you speaking to one another. You're only speaking to me.
Yes, Your Honor.
Ms. Shearer, tell me what's been why do you and Ms. Woodward have this beef going on? What's the underlying story there?
We were friends, and then one day she started sending me awful messages on Facebook Messenger, and because I didn't give her the response that she was wanting, she showed up at my front door with my children present in my home. She busted through my front door when I opened it because she said she just wanted to have a conversation, and then she proceeded to assault me on my living room floor, beat the crap out of me, giving me a moderate concussion, a bloody nose, bruises all over my body in front of my 1-year-old son and my 14-year-old son, who was begging Alana to get off of me, and the neighbor had to come and pull her off of me. I did not even touch her.
That is not true, Your Honor. There are multiple.
Okay. Yeah,
That is
I haven't
true.
asked you anything yet, Ms. Woodward.
Yeah.
That is true.
And is that what the police report was filed on? Was it that, or was it the driving incident?
The driving incident.
Okay, now let me ask, this is to Ms. Shearer.
Oh,
There were police reports for both incidents, and Alana was charged for the assault that she did on me. And yes, it happened. And since then, other neighbors are threatening to assault me because of Alana. I don't even feel safe in my home now. They're trying to force me out of my apartments.
Okay. All right. So you currently have a protection order against Ms. Woodward, and that order expires next July. Okay.
may I say something, Your Honor?
Ms. Paz, yes, go ahead.
The reason for me being there was my 4-year-old grandson was being bullied by me, since home crying while she was screaming at the other kids in the complex.
So
So I
her
went to
4-year-old grandson was not present.
Ms. Shearer, do not say a word unless I ask you a question, please. You sit and listen. That's all you do.
The reason for me to go there was to assist my daughter in calling the sheriff's department in order to figure out what we could do for her screaming at all the kids in the neighborhood for the last 2 weeks. Because once this thing happened with her and my daughter, everything was fine. The kids played fine. We all played at the park together. Nobody said a word to anybody for at least 2 months, a month. And then within the last 2 weeks before this incident, my grandson had came home about 4 or 5 times crying that she was yelling at everybody not to play with him. He's 4 years old. He doesn't understand. We just didn't know what else we could do when somebody is screaming at a 4-year-old.
All right. Thank you.
May I say something?
No, not yet. I'll let you know.
Okay.
And Ms. Paz, do you live in the same unit, or you were just there visiting your daughter?
I was just going there because my daughter was going to call the police. I live at a different residence.
Okay.
I only go there to assist my daughter. I barely even see Jamie.
Ms. Paz, I have continued the temporary order that I previously entered in this case. You're to have no contact with Ms. Shearer or her children and not harm them in any way. And you are ordered to stay 10 feet away from Ms. Shearer and her children, and 10 feet from their residence, 10 feet from the vehicle owned by Ms. Shearer, and 10 feet away from her children.
Understand, Your Honor.
This order will be in effect for 1 year from today's date. Ms. Shearer, if you need to have it renewed, you'll have to petition the court at that time.
Thank you, Your Honor.
All right. Thank you, Ms. Paz. And
Am I free to-
you're free to go. I've signed the order. It doesn't need to be reserved since you both were present. And if you wish to get a copy of the order, you're welcome to contact district court to receive a copy.
Thank you, Your Honor.
Thank you. And Ms. Woodward and Ms. Shearer and Ms. Woodward, looks like we did not issue a temporary order at the time of your last hearing. Tell me briefly why you think you need a protection order.
Been so many situations. This protection order is more for my children than it is for me. Jamie bullying my son, yelling at my son, like my mom said. He come home crying on occasions. I'm normally outside with him. I just stay on the back porch or on the front porch because anytime I'm anywhere else located in the apartment, this is seems to be very triggering for Miss Shearer. She's tried to call the police for multiple occasions. The police have told themselves that I should get a protection order against her. My attorney has told me to get a protection order against her because the things that she's been doing should not be okay. They should not be allowed. My son, like my mom said, is only 4 years old, and I've tried to explain to him multiple times about, why this is happening and everything, but an adult should not be able to bully a 4-year-old the way that she does. She also yells at the neighbors' children. All of the parents are too scared to say something to her. One of them has tried to say something to her the other day, and Jamie was screaming at her in the parking lot, as well as her son, for just simply saying kid. He's not allowed to just, live freely in our apartment complex because of her. And I just don't know what else to do other than to get a protection order for him so she can. Or I don't know what party it is, but bullying other children in the neighborhood who are not even her own, if they play with my son or, are kind to my son, they're not allowed to play with her children, and her children have to come inside. She's like causing this big thing in our apartment complex, and it's just getting ridiculous. And these are all children, and she's a grown up doing this.
All right, thank you. Ms. Shearer.
Hi.
Anything you want to say about the allegation that you've been speaking
Absolutely.
to?
Absolutely. I would
Child.
never yell. I would never yell at a 4-year-old. That is crazy. Also, who is she to say how I act around kids when she beat me up in front of my children? So,
Okay,
first of all,
that's
I
not
want to tell you, I want to tell you,
Ms. Shearer, stop.
I'm trying to
Answer
tell
my
you.
question. Okay, my question is, do you have contact with Ms. Woodward's children? I'm not worried about Ms. Woodward. I'm just asking her children.
No, in fact, my nephew plays with her child, and that's fine. But tell me why my 15-year-old and 10-year-old would want to play with her kid. There is absolutely no way they even want to play with her 4-year-old. She's like trying to force it to happen. And the other neighbor kids don't play with her kid over my kids because they've been friends with my kids for the 8 years we've lived here. We've lived here longer than she has. So I don't tell the other kids not to play with her kid. I tell them not to play with my kids at the same time as her kid. And as a mother, that is within my right to not have her children or anyone associated with her around my children after the assault. I don't want anybody in her family or in her circle to associate with my family. In fact, I have a protection order against Alana, which involves my kids, so she shouldn't be nowhere near my kids. And Alana came into my parking lot near my home the other day. She doesn't stay away from my home.
Okay, thank you.
Mm-hmm. And when her kid says hi, I say hi. I'm nice to him.
No, you're not. He doesn't say hi.
Stop.
You're not supposed to talk to me. We have a protection order. I just want them to leave me alone.
So, Ms. Shearer, I have ordered that you have no contact with Ms. Woodward or her children.
That's fine. I haven't contacted her since she assaulted me.
Just listen to me, please. You're to have no contact with Ms. Woodward or her children. Those are the only restrictions on this order. This order will be in effect for 1 year from today's date. Ms. Woodward, if you need it renewed, you have to come back to court and ask for that. You both are present here. Ms. Shearer, you've heard what the restrictions are, that you have no contact with Ms. Woodward or her children.
I already
And
don't, so that's fine with me.
A copy of the order that I've signed will be available to each of you if you wish to get a copy of it through district court, but it does not need to be served since you're both present. All right, thank you both.
Your Honor, may I ask a question, please?
What's the question?
Why is she getting a protection order when she assaulted me? That's insane.
No, it's because of the allegation that you've had contact with her children over her.
I haven't.
Okay, well, she said you did. So I hear you. Okay, I'm not arguing. Miss Sure, you'd have this tendency to argue all the time. I've listened to the two of you. I've made my decision. Thank you.
Okay.
Bye-bye.
May I please keep my kids from her children?
Ms. Shearer, goodbye.
Against Monica Wyachek. Monica Wyachek. 24G3059908.
Break the podium.
Yeah, Ms. Wyachek, you can come up here. Your name?
Larsa.
All right, so you have one prior violation. It is alleged you failed to refrain from consuming alcohol. Testing positive September 16th of 25. You have one prior technical violation. You plead guilty here, you could get 10 days. Do you understand that? This would be your second technical violation. Do you understand that?
Yes.
And they think you tested positive on September 16th of 25. Do you understand that?
Yes.
You can sign the advice of rights. Did you read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand it? We won't have a hearing if you plead guilty. You understand that?
Yes.
Do you understand what I said? You have the right to a lawyer. If you cannot, I will appoint you one whether you can afford one or not right now. You want a lawyer?
One lawyer just to explain myself.
We're going to give you a lawyer. I'm going to enter a not guilty plea. You're going to go meet with an attorney. And then I'm going to have, as soon as you're done talking to the lawyer, the two of you will come in here and I will conduct a hearing or maybe.
I understand that. Yeah.
All right. Welcome home. He'll set you up. Good luck. Mr. Lennon? Tyler Patrick Lennon, Q5B146836. Your name?
I
know. You're going to plead impeding. Why are you driving so fast?
That's what they do.
Is your mom or dad here with you?
Yes.
You got to slow down. Okay?
Sure.
I mean, you're going 79 and a 50. You want to be a NASCAR driver? Why are you driving so fast? I'm serious. On Telegraph, you're going almost 80 miles an hour. I mean, I appreciate you dressing up today. Turn around. See how this young man's dressed? Huh? I'm not trying to embarrass him. He shows some respect, which I appreciate. Don't ever forget that. Unlike the government, think they can. Have I said enough? Have I said enough about you driving like a maniac? You're going to plead to impeding, right? You got to slow down though, son. How long you had your license?
It's coming up for the year.
You're going to be pushing the car. You keep driving like this. To be charged impeding, responsible or not responsible? Please accepted 160. Slow down, please. What year are you in school?
I'm a senior.
Going where?
Whatever.
How you doing in school?
Good.
What are you doing next year?
I have been around.
Do you pay the 160 or do you need the time? Good luck. Appreciate you coming in looking that way. Thank you. Okay, Alyssa Maureen Counts, 25T 645-102. Good morning, ma'am.
Good morning.
Your name?
Also,
Did they offer you impeding or you just didn't want?
they did call.
They didn't offer?
Where?
There was no accident here, was there?
No, I was hoping to like review the television.
I can't hear you.
I was hoping to review with the dash cam and see if I ran it or not. That's what I was requesting in info.
Okay. But you know, if you go to hearing and you lose, these points are assessed, right?
Yeah.
All right. You want me to set an informal, right?
Yes.
Okay. Okay. I'm not trying to push it. You understand impeding 0 points won't go on your record, right? And you understand if you go to a hearing on this and you're convicted, the points are assessed and it goes on their record, right?
Yes.
Okay. Lisa, give me a informal hearing date.
October 2nd at 9.
October 2nd?
Yes. Oh, I'm sorry. That's this week.
Yeah. So
October 9th.
Okay. October 9th at 9 o'clock. Okay. All right. Have a good day. You can go down the hall and get your notice. Okay. Right down the end of the hall to the judicial clerk. Proctor. Jordan Nicole Proctor. 25B149339. A and B. Good morning. Your name? Hang on one second. Got to focus in here. You got to be careful. Right?
Yeah.
So you're going to have to plead the improper pass. Is that what they got going here? To that charge, responsible or not responsible? That's on 339B and on 339A.
Just in case you have any questions, Your Honor.
Just tell me your name.
Officer DeGuapo.
Tell me exactly what she was doing. Were you the issuing officer?
I was not. I'm just here. Because I told her the improper passing, she might need to accept that one in your courtroom. I don't know if you'd be willing to assist in that charge. And I forgot what the offer was I made on the article.
Who's your mom or dad? They with you? I hope your dad has a lot of money to pay insurance rates. That would be careful. Listen, young lady, please listen to me. What grade are you in? Junior? Where do you go to school at? Why are you driving like this?
Passing my boyfriend because he kept rechecking me.
He what?
My boyfriend kept rechecking me. And
Rechecking you?
no, recheck.
Is your boyfriend here with? Where's he at? So he's playing games like that, brake checking you?
Yeah.
You guys go over to Sportway, you can brake check one another in those go-karts.
Yeah, and I passed him in after that. And then I also had my ways out of art. I should have this, 55. I don't know that.
Yeah.
On West?
But
I don't care if you do impeding. I'm okay.
Okay, I'm willing to offer it.
Why don't you change these on here, will you? Listen. Cars are not toys. You don't want to, you seem like a really nice kid. You can't be doing this, okay? I'm serious. You only tell your boyfriend next time I'm gonna make him come in if he's brake checking you. And he's gonna have to listen to me for 20 minutes. Okay? All right, have a seat and get that rewritten up. Jordan Nicole Proctor, 25B149339, A and B. Your name? All right, yeah, you're gonna get impeding, but you gotta slow down and be careful, okay? You understand? All right, on file A to the charge impeding traffic, responsible or not responsible? On file B, responsible or not responsible? All right, I'll accept the plea, dismiss the original charges, $155 each. Do you need time or can you pay this? Slow down. All right, good luck. Have a good day. All right, come on up here, Mr. Braska. People against Joseph. Adam Braska. 19F2P1964.
Good morning, Judge. I can get her back. Joseph Rasta.
All right, does he stand mute waveform reading?
Yes.
Not guilty, please enter. Where does he work? Where does he live? And how much money does he make?
He's currently homeless. He was trying to actually work on DoorDash and he was picked up because he lost his job. He used to work in landscaping, Judge, and he lost his job. He was actually in the parking lot waiting for orders when the officers picked him up on warrant. So he doesn't have any money, Judge.
You gotta show up in court. Me haven't been here in 6 years. 2010%, sorry. You gotta show up. I'm gonna give you October 2. That's the earliest date I can do it at 9:30. Okay, but Gibraltar's here that day, and we'll take care of it that day. You cannot leave the state without consent or violate a law. You must appear in court as directed. You gotta show up. You got warrants too. I mean, you got.
I did inform him of the outstanding warrants.
You gotta show up. That's what I'll do. October 2nd. Good luck. Have a seat, sir. Safer Peter Despotis. How you doing? 25W9844. Your name?
Septem Despotis.
How you doing?
I'm doing just fine after 30 years that I've seen.
You haven't seen me in 30 years?
I'm sorry?
You said after 30 years?
It's been 30 years since I've seen it. Well, when you guys opened up your office on Middle on Jefferson there.
In Trenton?
Yeah.
What, you were a client of mine?
I wired up your building.
Oh, you know what? That's my brother.
I'm sorry?
That's my brother. He's the one with the
my brother, yeah.
Yeah. He's the one with all the money.
Yeah.
Right. Okay, so you're going to plead to impeding traffic, right?
Well, what happened is I was using my granddaughter's car because mine was down. And the integers on the speedometer was 10, 30, 50, which I didn't notice. I thought it was 10, 20 plus. And
but is this what you want to do? Is plead to impeding? Wait. Do you want to plead to impeding traffic? 0 points won't go on your record.
Yeah, that's fine.
All right. To that charge, responsible or not responsible?
I guess I'm responsible.
All right. 150.
All right.
You're all set. Won't go on your record. Best of luck to you.
Thank you so much.
Have a good.
Bye.
All the way down the end of the hall. Don't follow this young lady out of here.
No.
You can follow this young lady. She'll show that.
Oh.
Thank you.
Okay. Have a good day.
You too. Thanks a lot. Jody Ann Coleman, 25W839479. Your name?
Jody Coleman.
All right. You're going to plead to impeding, right?
Yep.
To that charge, responsible or not responsible?
Responsible.
150, you're all set. Original charge dismissed. Good luck. Ayala Kelly Harvick. 25T646346. And could I have Natasha Wagner and Mohammed Sawela seated at the table here? Mason, can you hear me? Your name, ma'am?
Probably Harvey.
You're going to plead to impeding, right?
Yeah.
Don't text and drag, okay? Too much happens. You understand what I'm saying? So that charge of impeding, responsible or not responsible. All right, please accept it. 185 is your total. Cash you around the hall to your right. That's dangerous. Don't do that anymore, okay?
So I spoke with the officer, and he told me that it was going to be way less than that because
It's what? Way less?
yeah,
It's a $210 ticket, $215.
Yeah.
They're not the judge. I'm not gonna change that. If anything, that's low.
Yeah, I told him, I spoke with him about what happened. I
Ma'am.
was not texting and driving.
Okay, well then you can fight the ticket if you want. You want me to withdraw the plea and set it for an informal?
Saying when he told me.
I'm not, he's not the judge. Whoever's telling people back there, they're wrong. Okay,
Well, that was.
ma'am, I'm gonna give you your choice. The police officers aren't the judge.
I understand.
I'm only telling you, you can either set it for hearing, and I'll let you withdraw your plea right now. And then I'll determine whether or not you were texting while driving. Listen to me, please. Or you can take this plea, and it's going to be 185. It's 215 on our list, and I'm not going to argue about it. I don't care what he told you back there.
I completely understand that. I was driving and
Okay.
I was not.
Let me call in Benars. I want Benars in here.
I wasn't able to speak.
Hang on.
With,
Yes, sir.
I need you to get Sergeant Benars in here.
Yes, sir. I'll find him right away.
If he told you that, I'll be glad to let you withdraw the plea. Johnny needs Benars. I called Will. He's getting. You saw in the ticket it said 215, right, ma'am?
yeah. So.
So when I give you 185, that means I'm cutting you down by $30.
And he just spoke with me and he told me that it would be like $100 less than what I was originally.
Oh no.
Told on the ticket.
No.
The only reason why I'm trying, if I actually did it, I have no problem with paying it. But the only reason why
He's telling you it was going to be $115. I've been charging anybody $115 on any kind of ticket like that unless it's expected. You keep interrupting me. And I'm just telling you, if he told you that, he and I are going to have words. You can have a seat. When he comes in, I'll recall it, okay? Cycle. I mean, using email device. Well, I want that file because I want the matters in here on that case.
What's the name of it?
What's your name again, young lady? Hargett. I need Hargett. So I don't know if you already took it down yet or not. All right, Monica Leanne Wyachek, 24G305-990A. And give him. Officer Dubois, I'm going to ask you to check in with us before you leave.
Okay, I do apologize.
That's all right. This gentleman has a case.
No.
No. I want Benars on here.
Du Bois. This is Trevor.
No.
I don't know what Du Bois says on.
This gentleman right here, Sawela, Martin Sawela, or whatever's. What's your name again, sir?
They.
That is with Benars.
This is a ship. No, he's with Trump. It's a Trump case. So he's with Trump.
There was another Brownstown case where I called, needed him back, wasn't there?
That was Ali.
Where's Ali at?
I have no idea.
So there was one with Ali probably out in the home. Hargett is with Trenton, and then this gentleman's with Trenton. Monica Leanne Wyachek, 24G305-990A. Your name, ma'am?
West.
She's charged with failure to refrain from consuming alcohol or drugs. She had one prior technical violation. What is she going to do here?
Pleading guilty.
I'm going to need Emily in here. Wait a minute. I want everybody to slow down. This is my fault a little bit. Just slow down. Back up. Did Sergeant Benars, I need to talk to you on these cases. Give me Hargett, John, and give me this gentleman's right here. I know I did. Have a seat, Durwood and Mrs. Wyachek. So I need you to stay here, if you would, Sergeant, until we call all of these. Okay?
Okay.
Ayala Kelly Hargett, 25T646346. Come on up here. Your name, Sergeant?
Sergeant Arthur.
So, your name?
Aaliyah parking.
So I took her plea. The fine schedule was 215. That's what the fine schedule is.
Okay.
I told her it was 185. She told me that you told her that it was going to be $100 less than the 250.
So it'd be cheaper. It's usually right around 150 is what I say.
Well, but remember, this is a $215 ticket.
I don't know if it adjusted. I don't know how the fines work.
Yeah, I know. I'd encourage you not to tell them that because I do float them around depending on what records are. I'm not going to reduce it. If you want me to allow you to withdraw the plea, I will. She says she didn't do it, is what she's saying.
Right. Yeah, we had that conversation.
So operating vehicle while on cell device, this is Officer Honeycutt. So I'm not going to reduce it, but I will allow you to withdraw the plea if that's what you want to do and set it for a formal. But if you set it for a formal, I want you to be aware, if you lose, this is going on your record. I'm not saying you're going to lose, but it is going to go on your record if that's what you decide to do.
Yeah.
Do you want a minute to think about it? Take a minute to think about it. Okay? Take a minute to think about it. In the meantime, recalling Monica Leanne Wychek. 4G 305-9908. All right, ma'am, your name again? Detective.
Sure, what makes about Monica
I'm
Watson?
missing detective.
This is Mr. Sato's case. She's also here one of the Zoom matters, so it's sharp today.
All right. So we need to call Emily in. If you plead guilty, she said she's going to plead guilty, right?
Yes.
If you plead guilty here, ma'am, you could get 10 days. Do you understand that? Did you sign the advice of rights form? Did you read it and understand it? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Nice and loud for me. For the charge of failure to refrain from consuming alcohol, testing positive on a chemical test on September 16 and 25, how do you plead?
Guilty.
Did you drink alcohol within the 3 days before that?
Yes.
Anybody force you to plead guilty?
No.
I'm going to accept your plea. Where did you drink at?
My house.
With who? I'm going to accept your plea. All right. Did somebody call Emily?
So,
Good. What do you want to tell me?
Judge, I think she was within 10 days of being off probation. She and her husband are both out of work. They've got extreme financial stress. They got the emergency plan. They're going through stuff with this time. Afraid of everything. We thought too much about.
Me?
Cedar.
All right. What are we going to do with her? Let me see the screening. Something reminded me. She was inpatient, and I believe this was the first offense, as I recall. She had a really, really high breathalyzer, blood draw, whatever the case may have been, as I recall. Could be wrong. Something else, too, wasn't there? Something else bothered me. There was an accident. Do you have the police report? You struck the back of the patrol car. I remember now. Okay. All right. Tell me, talk to me. What are we going to do with her?
So she's done everything. Really, she's just maintaining as far as meetings, treatment, and testing. I did just print her testing before I came in here, and she missed over the weekend on the 26th. So I didn't get a chance to amend the order.
She admits over the weekend she's
missed over the weekend. She missed out on the lessons over the weekend.
Oh, I didn't know that. I've been doing it for 15 months. I didn't even know. It's really funny. I usually. I tried it for I in the last 6.
you're still working, right? What happened?
Oh, I got let go.
Not as a result of this.
Let go on his 15th. I was trying to pull out as long as I could, but I got my husband to get back to work, and it's kind of bleeding me.
What's going on with why'd they let you go?
Well, I've been working 13, 14 hours a day for the last 10 months. I don't get home to bring. I haven't been home for my kids or anything. They have like a point system, so I've been coming in late, and they just had to let me go. But they told me if I put in my 2 weeks notice that they can rehire me, but it's like a different director and all this stuff, so I don't have that time to wait for it because now I'm out of work and I'm the only one that's paying all the bills and doing everything. Now I'm ran out of money. So that's why
Is DNA open? You're going to okay, hang on a second, just slow down. I'm accepting your plea. I'm handing you this pad. I want you to go test the DNA today. Okay, you're going to test the DNA today. What's that? Oh, this.
Yes, thank you.
You're going to test the DNA today, and then you're going to come back for sentencing. All right. Where is the registered there? Okay, so defendant to test today. When is Mr. Haynes here again? When can we set this sentence for?
October 27th at 8:30.
Actually, I don't have anything earlier than that.
Your next probation day is a holiday.
Yeesh.
There are other days when I'm here.
Yeah, give me a date when you're here.
17. I figure out next week on the 6th, doing arrangements.
We'll have the test back by then. October 6th at 8:30. Okay? Yeah.
I'm getting the lunch. It's not a big deal.
Yeah. October 6th at 8:30. Okay? All right. Thank you.
Do you want her to continue? Do you want to change your testing at all or leave it as it?
No, just leave it as it is. We're going to see what happens. I'm off on Friday. All right, go test today. We'll see what we're going to do. Just relax, one day at a time, okay? Ayala Kelly Hargett, 25T646346. So you tell me what you want me to do, man. Your name? You want to withdraw your plea, or do you want and go to hearing on the operating while texting, or do you want to have a
I'll take responsibility, but I get 30 days to pay it.
Sure. So you understand it's still going to be 185. Yes? Where do you work at?
In office.
We pay $40 each week. How about we do that? And we'll start it on October the 10th. I'm sorry. Yeah, October the 10th. Okay? If you ever don't have the money, just call the court. We'll go on Zoom, honor before the due date, or you can walk in here, honor before the due date. Okay? Good luck. Where's Jackson Farrell? People against Jackson Farrell, 24B 82280. Name?
Hello.
Your name?
Jackson Farrell.
Property to be cleaned up and in compliance with the ordinance on August 31. I think you were were you not the guy that got smart with me last time?
No, sir. I was just trying to explain.
No, you were getting smart with me. Did you not tell me I came out and took pictures of your property even though you had no trespass signs?
Yes, you did.
You know why I remember that? Because
Why?
I would never do such a thing. I don't do things like that. And
Sir, I'm not here to argue with you about that.
Listen, I'm just telling you, get anywhere near as smart with me as you did last time. You and I are going to have a big problem. Do we understand one another?
Yes, we do, sir.
It's going to be a massive problem. Do you understand me?
Yes, I'm not here to argue about anything.
No, you're here to show disrespect for the judicial system.
No, I'm not.
And don't interrupt me again, or else I'll make you come here. I'm telling you, you're not going to play this little woe's me blind. You got me?
Pardon? I couldn't hear you, sir.
I'm going to arraign you on this charge. You're charged with failure to clean the property and comply with all township ordinances by August the 31 of 25. That is what I ordered on July the 3rd. I also, in full disclosure, this was sent to probation in anticipation of Monday's show cause hearing. This was provided to me. So in fairness, I'm going to read it to you. Probation has this on top of the probation charge. I had Rob conduct an additional field inspection of the property. According to Rob, Mr. Farrell remains non-compliant. The only changes have been an unpermitted fence was installed, as was an unauthorized accessory structure in the backyard. The wood on the garage in the house is rotting and allowing animals to harbor in the eaves. I've attached photos should you need them for the hearing. Rob has attempted to contact Mr. Farrell to schedule a compliance inspection with no success. So all photos of the backyard have been taken from the neighbor's house. So I'm just telling you what the charge is. If you plead guilty or if you are found guilty, you could be incarcerated on this charge. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in your own witnesses, to testify or remain silent. If you remain silent, that silence will not be held against you. You have the right to testify, again, or remain silent. And if you remain silent, I won't hold it against you, and you'll have the right to bring in your own witnesses to cross-examine theirs and to have a full-blown hearing if you want. Do you understand that?
Yes, I do.
If you plead guilty at any time, you'll be giving up all those rights, and there will be no hearing. Do you understand that?
Yes.
You have the right to a lawyer. I'll be happy to give you one now at public expense. Do you understand that?
Yes.
Would you like a lawyer?
I need one, yes.
I'm going to give you one right now. You're going to meet with the lawyer, and then I'm entering a not guilty plea for you, by the way. And then you and the lawyer are coming back in here today. Okay?
When?
Today. We're going to have the hearing today. Okay?
How am I supposed to talk to the attorney?
They're going to put you in a breakout room, and you'll have the opportunity to talk.
Okay. Well, who is this person, Rob?
He's from the building department, I think.
Okay. Well, there have been no attempts to contact me by phone.
Listen. Your lawyer can bring all that up. Your lawyer can bring all that up for you. I'm going to put you in a breakout room. You're going to speak to the lawyer. I'm still going to be fair with you, even though I thought you were incredibly disrespectful, because because I still respect the system. Okay? I have respect for the system because my family's been in this profession for 98 years. So I'm going to still treat you fairly, but you get smug with me again, you will have a big problem. Court's in recess. Put him in a breakout room with the lawyer. Thank you.
Thank you.
Jackson Farrell. Thanks a lot, Ms. Tessino. 24B 82280. All right, Mr. Farrell, your name?
Jackson Farrell.
Ms. Wilds, he wants a hearing. Your name?
Elizabeth Bosway-Shana.
James. If you feel you can adequately handle this, otherwise I'll put it over until Wednesday.
I feel that I can justify my violation, Your Honor.
All right, so I'm going to ask you to raise your right hand. You don't have to raise your hand, Mr. Farrell. That's only if you're going to be testifying. Ms. Wilds, You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Yes, Your Honor. On the sole violation, the defendant failed to clean his property and comply with all township ordinances by August 31, 2025. Defendant was sentenced July 30th of this year. I was ordered by Your Honor to comply with all township ordinances and to permit township officials to enter the property for compliance verification. He was also ordered for that property to be cleaned up and in compliance with all ordinances, with all township ordinances, by August 31 of 20. Mr. Farrell was given a copy of his order of probation. I also included a letter that I typed indicating the same information, that the property needed to be cleaned up by August 31, 2025 in compliance with all township ordinances. So he received it 3 different ways: verbally from you, in writing from myself, as well as in writing from the order of probation. I contacted Caitlin, who is the prosecutor of Brownstown. She indicated to me at the beginning of September that the property still had not been cleaned up. Then the show cause was issued. I was contacted by her again, as well as Mr. Harris, Rob Harris, who's the township building official, on Friday, September 25th, indicating that there had been no movement as far as the cleanup was concerned, other than additional ordinance violations or possible ordinance violations in which an outer building was erected, as well as a fence was installed, both of which were not done by permit or within township guidelines. I attached those pictures to the blueback for court. I think council has seen those as far as the condition of the home as it sits today. I did communicate also with Mr. Harris, the township building inspector, today. He indicated that as of today, nothing was done over the weekend. This email back and forth between him and I probably occurred an hour ago. And again, 0 progress on the cleanup of the yard.
Any questions, over?
Have you been contacted at all on the same barrel 7:30?
Yes.
And did he ask for more time?
He indicated to me that he thought he had to the end of October. I did correct him, and I let him know that he would be in court to speak with the judge.
Does your client wish to testify?
You wish to testify, Mr. Farrell?
Pardon?
Do you wish to testify? If you do, I'm going to swear you to an oath.
Okay. Swear me in.
Is that what you want?
I believe so.
Okay. Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
So help me God.
Okay. You can go ahead and ask some questions.
Mr. Farrell, did you know that you had to file this order by August 31st?
Yeah, I thought it was till October. I know prior counsel had requested more time due to my disabilities and only be able to, travel to Brownstown 2 days out of the week, and that was on the weekend. And there has been a great effort to clean the property up, and it is just a few things that are left that will be gotten out of there. I don't know what else they're complaining about. My daughter put up a greenhouse, if that's what they're talking about being an illegal structure.
Did you talk to Ms. Wiles in September about the property?
No, I don't believe I did.
Did you have a conversation when she told you that in September that this had to be done by August 31st?
No.
Did you listen to me when I said August 31st at the time of the sentence?
I thought that prior counsel had requested more time.
I don't care if they requested until Jesus is coming back to the world. I told you August 31.
Oh, sir, I have so many disabilities and I'm physically unable to do all of this. I have to rely on 3 children to help. And we've been doing with due diligence everything we can to clear the property of any and all
This
problems.
looks like a junkyard.
No, it is.
This looks like a junkyard. I mean, you ought to be embarrassed for yourself.
I'm not privy to the pictures that you are, sir.
Well,
There's been no discovery sent to me so that I can see what they're talking about.
Anything else? Any questions of them?
I have no questions of them.
Any argument?
Since we renew our transfer down, and I been informed by Mr. Farrell that he could have us all done by October 31st, and we can't do it immediately just because of the fiscal.
He's known about it since 24. Court finds him guilty as charged. He failed to comply with all township ordinances and the permit township officials. I'm sorry, failed to comply with all township ordinances and failed to have the property cleaned up. To comply with all ordinances by August 31, 25. Court finds him guilty as charged. Now, this has been going on since 2024.
Sir, I was not advised of anything. I did not.
Mr. Farrell, I just sent somebody else to jail that was older than you on one of these.
Sir,
I am not going to hesitate. I don't want to hear it. Now I have a report here from somebody else, says that from Brownstown, saying that an unauthorized accessory structure was put in the backyard and an unpermitted fence was installed at your property. Now your daughter lives there. The only thing I can tell you is maybe that you need to control her. So if she's okay with her dad going to jail, that's fine. I'm setting an in-person sentence date. You're going to have to show up here in person. And I'm going to promise you something. Give me a date in 2 weeks. Are you here? Can I get you here on a Wednesday, even by Zoom? Or Thursday, Lisa, when Brownstown's here.
Judge, I can do Thursday, October 23rd on Zoom, either early morning, like right at the beginning, or late morning.
He's got 2 weeks to have this property cleaned up or he's going to jail. So if I have to give him another lawyer, I will. If you can appear by Zoom, that's fine. I want Brownstown here on my docket day, and I'm going to need Mr. Haynes and the defendant in person. So you do the best. You can't do it on a Wednesday or Thursday, even by Zoom?
Well, you said him in person, me on Zoom?
Correct.
October 9th.
I'm going to give him 2 weeks to the 13th or something like that. Well,
The 9th is a Thursday. They're only here on Wednesdays. They're here for you on October 8th and October 22nd. And then we have a carryover day on Thursday, the 16th.
Are they not here the 16th?
Yeah, I just said that. They have a carryover day on the 16th.
Can you not do the 16th by Zoom?
We did it at like 11:30.
October 16th at 11:30 a.m. You have to be in person, Mr. Farrell. You're going to go to jail if this property is not cleaned up to my satisfaction. You guys think you don't have the rules applying to you? It's that simple. I wish you well. You're going to have to figure out a way to get here in person, and you're going to go to jail if that property isn't cleaned up. Do we understand one another?
Yes. What exactly are the issues that...
Everything. Your place is a junkyard. I can't believe if this place was 27 miles out in the country with not another house around, maybe, just maybe, nobody would care. This is in Dawnshire subdivision, right?
I don't know.
Where's Donnelly Street? It's on Sibley and close to Allen, right? It's east of Allen on Sibley, off of Sibley, south of Sibley.
Sibley and Graco.
I'm telling you, this property is going to be cleaned up. If it isn't, you're not going to like it at all, what is going to happen.
That's what I've been trying to do, sir, is clean it up.
You've had since 2024.
I was not aware of it.
I'm not going to argue with you. I'm just telling you, I'm forewarning you. I don't relish putting people in jail, especially on these. But I'm telling you right now, No neighbor should have to look at this junkyard. Period. Not to mention the dangerous condition that the property is in, not to mention that your daughter apparently either doesn't care or thinks she's larger than life by putting in structures without permits. I'll see you here then. I'm not going to argue with you. You have to be in person. Best of luck.
What date and time?
I just told you that. I'm not going to have to repeat everything to you 3 times. You're coming here October 16. October 16 at 11:30. And the only reason that you've got 17 days from today's date is the lawyer isn't available. Otherwise, it would have been 14 days. It's 20 to 12, great weather. I'd get somebody out there by 12 o'clock today and get started, because that is not going to be cleaned up overnight. Good luck. Thank you.
All right, welcome everyone. It's time for our misdemeanor sentences. Our first matter is People versus Robert D. Burns. File number is 251318. This is a domestic violence case. I accepted the defendant's plea, set the matter for sentencing for this morning. Wanted to get more information and victim input. We did get a restitution request. Jordan Harden is here with the defendant, and Angelique Camfield is here on behalf of the prosecution. Ms. Harden, what would you like me to know here?
Thank you, Your Honor. Mr. Burns did serve a good amount of time on this case at the upfront. Since release at the time of plea, he has gotten independent housing with his father, set out away from the complaining witness. They do not have a relationship, and he has no desire to continue such relationship. He is working. He works for Baja, which is a company that essentially sets up and tears down all the fair rides and things of that nature. So he's been busy lately with that. He does understand there's a restitution request and indicates today he's able to make a payment towards that, but would need a payment plan to finish paying that off. In my notes with Prosecutor Robert, because this plea was taken back on August 1st, we did set it up quite a ways. But Mr. Robert, at that time, my notes indicate had no objection to a time served just due to the amount of time he did up on the upfront. If the court did feel a probation was necessary due to the restitution component, I would ask for a non-reporting probation to ensure that that payment is made towards the restitution. Again, Mr. Burns has complied with all terms of bond. He has made no efforts to contact the complaining witness. He reports to me that she has tried to reach out over multiple social media accounts of his, but he has blocked her on those in an attempt to remain compliant with bond. He also, again, indicates no desire to continue a relationship with her. So I don't think we're going to see Mr. Burns again. He's done everything he's needed to since he was released, and he's complied with all terms of bond. So I would ask the court to impose time served as well as fines and costs, and if probation is necessary due to the restitution component, that be done on a non-reporting basis. Thank you.
The defendant did spend 27 days in jail. I did a PR bond at the time of although at the time of the plea, he no longer had a right to have a bond, but normally, unless the defendant posts bond within 28 days in a misdemeanor case, they're allowed to have a PR bond. This restitution is actually for the apartment where the defendant was living, or the complainant was living. And there is a work order attached to it. Ms. Camfield, what would you like me to know?
Your Honor, my office will have to stand by the request for restitution and Mr. Robert's offer of credit for time served. I don't have
any additional input from the complaining witness.
I don't have a copy of the pre-sentence report, Your Honor.
There isn't one.
Okay.
I simply set it out. I want to get the police report. There's a video which shows him doing at least some of the conduct that resulted in his conviction. I didn't think we had any victim input, but I set it for this. The defendant is probably eligible for a deferral, but I don't think he's interested in it.
Well, we were interested, Your Honor. Mr. Robert said because he has a prior R&O on his record, he would not offer that.
All right. Yeah, I can't do a deferral without the prosecutor's consent.
He was very much interested, but Mr. O'Bear, was not willing to agree to that, so.
All right, if I knew that, I forgot it. Let me put a note in here, prosecution opposed, deferral. All right, so do you travel with this job?
Yes, sir. Yes, sir.
Well, you're here now. You should be able to pay this.
I believe he did say he could make a payment today.
Yes, if needed to be, I'd be able to make a payment today.
All right, we're to 27 days credit, 27 days. There's a $75 fine, a $75 crime victims' rights fee, a $50 state minimum fee, $100 and $50 attorney fee, restitution of $400. I believe that goes to Gateway Village. That adds up to $775, I think. No, 700. 350, 750. How much can you pay today?
Probably like $50.
All right.
But next paycheck I'd be able to do about 400.
All right, today. I'll make this due by December 1.
Yes, sir.
This will show on your record as a domestic violence, prohibit you from using or possessing a firearm for at least 8 years. I don't know if you like to hunt, but you can't in light of this conviction. Unless you have your firearm privileges restored. So at this time of year, do all those sort of things head south?
You talking about my
Yeah,
job?
your work.
It's seasonal, so yeah. So I would have to apply for another job, but I know we have two more this month.
All right.
So I will be able to.
I'll ask the court officer to take you out. You can make that payment. Make sure we got your correct contact information.
Yes, sir.
27 days, credit 27 days.
Thank you.
No victim input. All right, you're good to go, sir.
Thank you. Thank you. Can I? You have a card? Okay.
This is an odd case, Ms. Camfield. Defendant pled without counsel. Keith Stickley was here at the time. Mr. Stickley requested that counsel be appointed to assist him with the sentence, but the recommendation was 7411 probation. Mr. Houghton, have you met and talked with Rhonda Ives?
Just through emails.
Okay. Well, at least you're in communication.
I'm currently in family treatment court now.
In what county?
Cass County. I started last week, Wednesday.
Okay. You actually live in Van Buren County, or is Decatur the address that you have in Cass County?
The address that you guys have, I believe, was my home address. But as of Wednesday, I moved into a sober living home.
Oh.
Family treatment court.
And where's that? Tim, you don't miss it. The walnuts are falling all over the street. There's nobody there to pick them up. I'm gonna go out with my leaf blower and blow all the walnuts into his yard.
Howie doesn't do that?
No. Well, I think Howie is mowing it, but they just fall so prodigiously. That was Tim's job, is picking up bushels of walnuts. Now he's not there to do it. A squirrel got one of them and broke it open on my front steps, and it made a big black stain that I can't get off. Tried brake cleaner and some other stuff. Simple Green. I didn't discover the secret. I'm gonna have to power wash it in the spring, I guess. All right, good morning, Ms. Ives.
Good morning, sir.
Your client's right here. And he filled me
We were
in.
looking for him. We weren't sure where he was.
Oh, I dragged him in here. He was out in the hall and I asked the officer to bring him in. Sounds like he's doing pretty good. Let's address the matter of People versus Christopher James Houghton. Just a moment. Who is this? Good morning. This is Judge Middleton.
You could have a seat next to me.
This is Judge Middleton. I'm on the bench, and whoever called you, they didn't call you from this number. So, all right. Good luck to you. Wrong number. This is file number 251099SM, People versus Christopher James Houghton. Mr. Houghton was charged with possession of a controlled substance for psilocybin mushrooms, which we see some. I was in college. Some guy was growing them in his room in pickle jars. But they are a controlled substance under Schedule 5. It's a 2-year high court misdemeanor to possess them. Mr. Houghton pled guilty without counsel at his arraignment, and Mr. Stickley, the chief public defender, recommended that counsel be appointed to assist with the sentence. It does appear to me that he would be eligible for 7411 probation unless I'm missing something. He has quite a bit of unpaid fines and costs here in St. Joe County. And he advised me he's already on probation in Cass County, and I didn't really want to double up. Ms. Ives, he indicated that he's been in contact with you via email, that he's present in a sober living house in Tawajak, and he's in family treatment court. Sounds like he's doing a lot better. What would you like me to know?
Well, Your Honor, what I was surprised to see is the representative from, it's a Cass County at Sober Living, appeared here in court on his behalf, caught me in the hallway, wanted to kind of give me an update. She was just kind of briefing me when we were trying to find Mr. Houghton, and then realized he was in here when we walked in. But it sounds like he's doing everything he's supposed to be doing. Now, I'm not sure what put him in.
Well,
Sober Living there.
one concern is, do you really want to be on 2 probations? If you do this probation, you would have a chance to have this charge taken off your record, use of a Schedule 5 controlled substance. But it might just put an awful lot of obligation on you. I could try to fashion the probation where you can do most of it over in Cass. But that's a question. You spent a day in jail. I have $200 of bond. And as she indicated, you're doing all the things that you should be doing. You got a lot of unpaid tickets, and you got a domestic violence. You got some other things where you owe money here. That frankly, I was just going to put as part of your probation that you pay all your existing fines and costs. Ms. Campfield, do you have any thoughts on this?
I do, Your Honor. Well, the first is, and I'm sure that he's already aware of it, but just to let Mr. Houghton know with his counsel present that this could have been charged as a felony. Possession of psilocybin or that type of a substance is actually a felony offense. So it's good that it was a misdemeanor here, that he's allowed to do 7411. It sounds like he's taking the appropriate steps to live a sober life. My suggestion would be that we place him on the 7411 probation and request that Cass allow a transfer for supervision purposes only. If he's doing all the things through their program that he ought to be doing for this one, such as testing when required, and the sober living home, that perhaps it be fashioned if he leaves that home AWOL without completing the program or test positive, that would be a violation here as well.
I think what I'll do is make it a condition of his probation that he comply. I'm going to waive his probation oversight fees here. And make it a condition of a probation that he comply with the probation. Which court are you through? Circuit court? Or is it abuse? Is it a probate court matter?
The family treatment court was a voluntary thing that I volunteered for.
But do you have a conviction of something?
I don't have a conviction over there.
All right, so you're not on probation, you're just in the program.
I'm in the program, yeah.
Is that correct, Mandy?
That is correct. I think you go in front, which judge do you go in front of, Cass, is it Herman?
I believe that's who it was.
Charles Herman or
Yeah.
Carol Beeler?
Carol Bueller is who I'm
All
saying,
right.
yes.
Okay.
Carol Bueller.
And he is subject to drug testing at least 3 times a week and also,
And it's all voluntary.
Yes, I volunteered for this.
Good for you. All right, this seems appropriate. I'm gonna do a 7411 probation for 1 year. 12 months, meaning you can get done in 6 months. I'm gonna order 11 days in jail credit. 1 of the 11 days, 10 are deferred. You did 1 day. I'm gonna hold some days over your head. You had a small amount of psilocybin mushrooms. But you're also driving a vehicle at the time, which is always scary to think that people will be operating a vehicle after using hallucinogenics. The fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee. I'm gonna waive the oversight fee because I'm gonna ask you to comply with all Cass County Family Treatment Court directives. What are you struggling with? It's not psilocybin mushrooms. Is it methamphetamine or alcohol or?
It was methamphetamine, yes.
All right.
I have a son that is in, his mom doesn't have custody of him either. And when I was given the chance to step up as a father, they asked me if I wanted to do family treatment court. So that's why I volunteered for it.
At some point, do you get to get out and get a job?
Up to their recommendation, yes. Hopefully soon.
All right, well, you're already ahead of the game. As I said, you owe me a bunch of unpaid stuff. And often guys that are struggling with meth, it's not on their radar to pay their fines and costs. So it's a condition of your probation that you pay outstanding St. Joe County fines and costs.
Your Honor, may I ask the court to request a release from the Family Court Treatment Program service providers so that we can ensure
Yes,
the
that's
7411 is complied with?
provide a release
Thank you.
to our court. All right, Mr. Holden, you're on the right path. We've seen a lot of people lately on the wrong path. But this ultimately, your goal would be to get custody of your son?
Yes.
All right, that's a worthwhile goal. All right, Ms. Ives, thank you. You came, you got appointed late to the game in this case, but your client seems to be doing what he needs to do. Mr. Houghton, I'm going to ask you to take this form downstairs to the probation department. We'll try to coordinate with Cass County's Family Treatment Court. Mandy, are you connected to that?
I am. I'm not specifically in treatment court, but I do work for the drug court over there as well as here.
All right, that's helpful. Well, you could be a good resource. All right, Mr. Houghton, I wish you the best.
Thank you.
Thank you, Judge.
Thank you. All right, now it's time for our next matters. What's your name, sir? What's your name?
Darren Yoder.
All right, let's take up Mr. Yoder's case. Why don't you have a seat with your lawyer there, Mr. Yoder? I did arraignments for Judge Pattison this morning. He had one Then we had a walk-in. We had another one that I missed because I didn't know I had him.
I'm sorry, Your Honor, I
No,
don't
it's-
have
no,
eardrums,
it's
so I
not.
can't hear very.
Oh,
very
yeah, you
well.
told me that. Let's try the system here. Those little, Michelle's an expert at these. Yeah, there's some headphones there.
How are you this morning?
I'm good, thank you. Better.
Mr. Yoder, does that help?
Yeah, that works.
All right, very good. All right, when they upgraded our system, they gave us these, and we do sometimes tend to overlook them, but they can be very helpful. This is file number 251128, People versus Darren Randall Yoder. Mr. Yoder is here with his lawyer, Jordan Harden, and Daniel Frazine is here. He drew this assignment. Also present is Angelique Canfield. Mr. Yoder's got quite a little baggage here on his record, and this is
The load of baggage, Your Honor.
Yes, sir.
Is all on my brother. He used my name. If you look up his name, you'll see that mine is AKA Darren Randall Yoder. So I have not committed any crimes. I'm not that kind of a person, Your Honor.
All right, well. All right.
I was literally, I mean, I'm not discounting the fact that I did have alcohol in my system.
But the person that went to prison back in the past was not you?
No, that was my brother.
He went to prison using your name?
Correct.
Stranger things have happened. Your driver's license.
I haven't had my driver's license since I was 18.
Well, you have an ID and your picture is on it. So
he's probably got some kind of a copy of it, maybe.
Well, it certainly looks like you in the picture.
But he looks almost identical to me. If this is not even an excuse, he looks almost identical to me. He knows my social security number because he stole my social security card.
He went to prison?
Yeah. His name is Timothy William Lewis Yoder.
Well, these are done by fingerprints.
I have not been arrested for anything.
All right. Well, you were arrested for this.
Oh, obviously for this, yes. I mean, we wouldn't be here otherwise.
No.
No, look up Timothy William Lewis Yoder, and you'll see that Darren Randall Yoder is his first AKA, and then you'll see that Timothy Brian Grandstaff is his second AKA. No, sir, I do not do anything to get in trouble. I made the wrong decision to move the car.
Okay, all right, don't tell me.
Oh, my apologies, my apologies. My apologies.
Well, he raised this when he spoke with you.
What was that?
Well, when you talked to the probation officer, you told him this.
Yes.
He must be awfully identical to you because the driving permit, the guy looks like you.
Yes, my brother looks almost exactly like me.
All right, we'll have to sort this out by fingerprints. The recommendation, Mr. Yoder, is for 45 days in jail. You're the drunkest defendant I've had in 2025. You have the highest blood alcohol level of anybody I've seen this year, and it's almost October. You're very, very intoxicated. You have very little insight into the level of addiction that you're struggling with. And part of his reason for the recommendation was your extensive criminal history. But your contention is that it isn't you.
No, that's not me though. I know that I made the wrong decision to maneuver a vehicle, number one, without having a license, even though that's put to the side. But intoxicated, understandably so. But it's not like I was trying to go from here to Ohio. I was literally moving the vehicle 2 parking spaces over. I admittedly
All right, stop.
My apologies.
All right. I don't know that he ever got printed here. It's one of my pet peeves with the sheriff's department is they often don't print people that they get in the jail. They have a different view of this. I don't work in there, but they don't print the people. Sometimes when they release them, we don't even know who they are. I can't tell. There is a fingerprint order in here directed. And so I believe the prints were taken here at the courthouse. Says you have a scar on your abdomen and a tattoo on your left arm.
Correct.
And your left forearm.
Correct.
All right, that's you?
Yes. I've got a scar right here from having rotator cuff surgery.
All right.
My abdomen, I was cut in half when I was a baby. I was one of the first in Michigan to have pyloric stenosis surgery.
All right. Ms. Canfield, do you have a thought on this?
It's
I'm asking the prosecutor.
It's very unusual when I'm looking at the Michigan Department of Corrections Otis site for Timothy Williams Lewis Yoder. It does have approximately 6 or 7 aliases, one of them being his brother's name. And it appears that this individual that served a sentence for methamphetamine has similar features to Mr. Yoder, but he has a little bit more hair because he's about 3 years younger. But it does appear that there's a multitude of tattoos listed here. Now, the interesting thing is when I searched the defendant's name and age, there wasn't a record that came up. And I searched for all status as opposed to active status. So I would think that if some of these felonies were on his record, I would have at least seen something. But one would think if they're charged with criminal sexual conduct in the first degree, that there would either be a record of it under Timothy's name, which there is not, or I would have an old Otis, but I don't know how long they keep those records in Otis. So that's the problem.
Well, they do DNA for those.
Correct. They would show the same male, the YSTR DNA from the same family line, but they would have different and unique. They should have different DNA because they're not identical twins. So,
well, all right,
but one would think it would have been addressed over the multiple years and years and years that his brother was catching felonies purportedly under his name.
Well, let's talk about let's talk about the criminal record. Most of it is not very relevant to this. It's old, and it's very old. There's no driving intoxicated. There's some old driving suspendeds on here. But let's assume that none of these are him. There was a DWLS August 1st of 2025 that was dismissed, I think perhaps as a part of this plea agreement.
That's correct.
So let's set the criminal history aside. The court will not consider any of the criminal history in the report, A, because it's old, and B, because there's a question about whether it's him. So let's proceed just on the facts of the case. With that in mind, Ms. Harden, what would you like me to know?
Thank you, Your Honor. As the court has indicated, this is Mr. Yoder's first drunk driving conviction and his first criminal charge in a couple of years. Mr. Frazine's recommendation indicated that he did not believe Mr. Yoder was a good candidate for probation. However, it's my understanding there's been no issue while on bond. He's gotten rides to court. He's appeared at court. He's been in communication with me. I think that he's someone that's worthy of affording the opportunity for probation too. Get him in some services. You know, him saying Mr. Frazine believes he doesn't have a problem. That might be the kind of person that probation could actually help if we get him engaged in some court-ordered services such as counseling, substance abuse treatment, things of that nature. He does have his fiance here who's a support system for him. I would ask the court to consider a probation and defer any requested jail time as this is his first conviction. Thank you.
Ms. Canfield, what's your thought?
Setting aside the history, as the court's indicated we will do for now, giving the defendant the benefit of the doubt that these may be his brother's convictions. He had an extremely high blood alcohol content. He indicated that he drove to pick up his girlfriend from work. So he did drive there. He was sipping on beer in the car as he waited for her to get out from work. And it wasn't just driving a couple spots down to change the parking location. He actually admitted that he drove there to pick her up. When you're at a 0.3 or above, you're a significant alcoholic. If you're functional at that level, as the court's well aware from handling sobriety court, it's a little frightening to think that he's on the road at that level. And as Mr. Frazine indicated, functional, most of us would be passed out or hospitalized from alcohol poisoning. So he's been drinking for a very long time, and he does have an alcohol abuse diagnosis, although I'm not a physician. That seems under the situation to be an appropriate thing. I would think that to have a substance abuse assessment done, we'd probably find some interesting facts in that regard, other than what he's just told Mr. Frazine. He's engaged in treatment before. Obviously, he still thinks that he can drink, which is not accurate. And he continues to violate the law in doing so. I see Mr. Frazine's point in getting a lot of different versions of events from the defendant throughout the course of his interview. If you don't recognize that you have an alcohol addiction, it's very difficult to rehabilitate from that. So it seems under those circumstances, the jail is appropriate. But I also see his counsel's point in that maybe he needs the services so that he can recognize he has an addiction and give him an opportunity to establish sobriety, not only from methamphetamine as he has in the past, but from alcohol now, because it seems one replaced the other. If there is a term of probation, I would think that 2 years would be adequate in consideration of the sobriety court program, but he has to be willing to engage. If not, perhaps regular probation is more appropriate if he can't handle the intensity of the sobriety court. But I do think some jail is more than appropriate given the alcohol level in his system at the time of driving.
Mr. Yoder, your preliminary breath test at the scene was a .388.
Correct, sir.
And on beer, that is just astounding.
Well,
Stop for a minute.
yes, sir.
And then they have to take you to the hospital if your blood alcohol is 0.32 or above.
Correct.
And so they took you to the hospital and they got a blood draw and the blood result came back at 351.
Mm-hmm.
Now, there may be some argument that you were drinking after you parked the vehicle, but you weren't legal to drive, A, because you didn't have a license, and B, because you had a blood alcohol about 5 times the legal limit. And you did drive there. You didn't drop out of outer space. You did drive it in the parking lot. And so here we are, and you've accepted responsibility. As Ms. Camfield said, your memory is not complete. And so you give slightly different versions of things, but nobody thinks that you're lying about anything. They just think that you have a hard time reporting accurately.
My memory has been shot for a long time,
Yeah.
sir.
All right, I'm gonna let you go last, but let's hear from Mr. Frazine.
Well, when I was speaking to him and he did tell me about his brother's situation, he did eventually admit to the juvenile crimes and failing to register. If that was his brother, as indeed he's trying to report here today, then he wouldn't have admitted to failure to register. So I don't think it's purposeful. I just think with this kind of alcohol consumption, your brain becomes a little bit less good with the facts. And I think this is what's happening. So even if we didn't take everything here and we did attribute to some of his brothers, he at least admitted to this. So that's why I kind of took everything else with a grain of salt. Also, when he tells me that he tried a duels, but it was too damn expensive. It's like $8 a 6-pack. And now I just sip on beer all day because it's cheaper than water. I mean, that's a hard thing to overcome. And when I spoke to him about probation, I explained to him in detail how that works. And he was leaning with, well, I just kind of rather get this over with. No job. He somewhat does DoorDash. My feeling is he's probably doing that just enough to supply himself with the alcohol because he's got it so bad.
Well, obviously he can't do DoorDash because he can't drive.
Right. He says his girlfriend's doing so. And that's why I said to him, I said, so really your girlfriend's doing the door dashing.
Correct.
So
correct.
Again, so how is he going to pay for testing? How is he going to get anywhere? How is he going to do this stuff? My take was we'd just be setting him up for more failure down the road and exasperating the things. My best hope with all this was that he'd do enough time where he'd say, well, this really stinks. I don't want to do that anymore.
Well, and some of these are these last few recent driving without a license cases, they're not your brother. They're the guy that lives at Whit Lake Road. There's a guy that looked me in the eye.
That would be all of these cases right now, I would believe.
No, they're you.
But normally I would think that a long 2-year probation would be appropriate, given the facts. If they had a license and they were able to do it and participate and even remotely thought they had a issue, but I just think we're setting them up for failure, but I'll leave it to the court's discretion.
I would be willing to participate.
All right. Mr. Yoder, I said I'd give you the last word. What do you want to tell me?
I made a mistake, Your Honor. I was trying to maneuver the vehicle around to go next to our friend who was door dashing, because there was a person that had parked in her spot that she normally parks in while we hang out, and my fiance is at work. I made the mistake of maneuvering the vehicle. I cannot deny it.
All right. You missed the picture. You drove the car there while you were like super drunk. I'm
I
not so
didn't
worried
drive
about.
the car. No, sir. No, sir. She drove the car there.
All right, so your contention is
She
you're
works
only,
at Taco Bell. She backed it up into that parking spot. I just went to maneuver around the vehicle, pardon me, that was next to us. I did not drive that car there. No, sir.
yeah, the only driving here is in the parking lot that they can establish.
Correct. And it was just to go around a vehicle to get next to another vehicle to have communication.
Well, you
stupid
dented this other
mistake.
guy's car to the extent of,
Do what?
you said it damaged his car less than $1,000 worth of damage.
I didn't touch anybody's vehicle.
There wasn't a scratch on, I'm sorry, there wasn't a single scratch on my car.
What the report says, and I wasn't there,
Obviously.
it was scratched to a crash. When I arrived, I spoke with a caller. He said he saw the driver, Darren Yoder, drinking alcohol in the parking lot before getting into a vehicle. Darren then hit the bumper of Noah's parked vehicle, leaving minor scratches. He said Darren seemed not all there.
Your Honor, the scratches.
I don't, whatever it was very apparently minor.
Yeah.
These cases are you. Darren Randall Yoder, 2022, disturbing the peace. Whit Lake Road address. That's not your brother, that's you.
At Whit Lake Road at 2022. I wasn't even in the state of Michigan in 2022.
3.
Me and my dog were out walking on the East Coast in 2022 to up to 2024.
23 is operating with no license. That's you. And then that's it. There was a fail to pay a booking fee.
A booking fee probably.
Was the 23 one you?
No, again.
All right, I'm gonna adjourn this. I'm gonna figure out what's what. You're either a terrible reporter of the facts or a huge liar. The picture on your driving record is you, unless your brother's identical to you.
He's almost identical, exactly.
Your fingerprints are on file. I've engaged with you before. I have video of me talking to you in the courtroom.
And I have no problem admitting any bit of the truth either.
All right, so the 23 one wasn't you and the 22 one wasn't you?
No, I was not even in the state of Michigan until 2024. Me and my dog, when me and my ex-wife split up.
Well, will your dog testify on your behalf?
I guarantee he will. He's in the car right now.
That's good. Put on.
No, him and I, we walked around the entire East Coast for 2 years until it was Father's Day of 20. Shit.
20. All right, just stop. I'm not even sure how to approach this.
I'm not a liar though, Your Honor.
Where is Timothy Yoder now?
I honestly don't know. I have no communication with him.
Well, did he live in the Whit Lake Road house?
He probably used the address, I would imagine, because he is partial owner. Him and I are both 12% or 12.5% owner of the property.
And you actually live there now?
Not currently. We just moved all my stuff from there, and I moved down to LaGrange with my fiance.
I don't even know how to do a forensic. When I was a young prosecutor, You weren't born yet. In order to prove someone was a habitual criminal, you had to prove they were the same person. So I tried a criminal sexual conduct charge against a man where the conduct occurred here in Centerville. And he allegedly and you had to prove the prior to the jurors. So first you finished the trial, and then you had to prove that it was the same guy that was a habitual offender. So I got his fingerprint records from Ohio and had someone who had been his probation officer, somebody in Ohio, had an FBI agent in the courtroom, took the defendant in the back, took his fingerprints, compared the fingerprints to the fingerprints in the Ohio record, and said he was the same guy. And the jurors convicted him of being a habitual offender also. That is like nearly impossible in this day and age. This was in the 80s. Well, that's what needs to happen, is somebody needs to look at the fingerprints and see whether it's the same person. And your own probation and parole agent, they would have knowledge of this. And I believe the person on the driving record is you, and I believe the guy I talked to in the courtroom in 2022 and 23 is you.
The only time that I've had any issue with any law enforcement was like 2018, something like that.
Well, how did your driver's license get suspended if you never?
Well, I was 18, honestly. I was 18. I was driving home from work.
I'm gonna go down the rabbit hole here. I'm gonna get the videos of our earlier proceedings, which include two 209 SM. And 23988 ST. And 152761. If I can. Jordan, when are you here next? You know?
I think the 13th of October.
All right, let's see what we got there.
I have set though. 4.
The only thing that I've actually been convicted of that I actually did, aside from this, was the felony conviction for selling my medicine. And that was trying to get my kids Halloween costumes.
Where was that?
That was in Sturgis.
All right.
I mean,
but you told Mr. Frazine you got convicted of failing to report under the Sex Offender Act.
I've been Romeo and Julieted out of that a long time ago.
But were you on the sex offender registration list for a number of years?
For 14 years I was, yes.
For something you didn't do?
Yes, I was 16. I had sex with my girlfriend who was 15, and her parents reported me as a rapist.
Well, that's what's in the report.
So, but I was
stop.
Yes,
You
sir.
are
Yes, sir.
sending me down the rabbit hole. I'm going to confirm that these are you, and if I do, bring your toothbrush because you're going to jail. But we'll revisit this on October 13th at 10:30 a.m. I will get the videos. You just acknowledged that the underlying sex offense was you.
Yes.
Which you previously denied. You acknowledge that the failure to register as a sex offender was you, which you previously denied, and then you denied everything else.
Correct, sir.
All right, well, we'll figure it out. I'll see you on October 13th at 10:30. And I'll get the videos of those earlier proceedings.
October 13th at 10:30, is that what?
Yes.
Can you go to the counter and get a notice
Yes.
while he's here? If you go to the district court office, they can give you a notice before you leave today.
If you take him out, we'll get a notice for him.
Thank you.
We'll figure it out. All right, I'm sorry, Tim. So we kind of.
Y'all have a wonderful day.
All right, I'll see you in October. Thank you.
Yes, sir.
Are we up next, Judge?
Yes.
Okay.
My bad.
I could not conceive that someone could go into the Department of Corrections. Mr. Richards, would you come up and have a seat and be on the Registration Act for years when it isn't the right person? The tattoos match, I bet the fingerprints match. And I don't know if he knows what the truth is. This is file number 25951SD. Mr. Richards is here with his lawyer, Mr. Timothy George. Also present is Autumn Kiefer from the Probation Department, who prepared the screening report, and Angelique Camfield from the prosecutor's office. This defendant got 2 drinking drivings in real short consequence. And this matter was reduced to a charge of impaired driving. Mr. George, what would you like me to know?
Well, thank you, Your Honor. I know that this is kind of the second time around with Mr. Richards. We were here, I believe it was the day after Labor Day. And we addressed the first case. And so I don't want to reiterate everything, but I think at the core of it is Mr. Richards understands how serious both of these situations were. We've had this conversation where I think just the lifestyle that he was living at the time, maybe he didn't realize it, but it was obviously putting himself at risk, putting others at risk. And, specifically, the first case was a really scary situation. And then got the second one while he was on bond for the first one. So I know since he's been in here, the last time he obviously did the sentence in jail that the court imposed after that. And he reports that he did do the assessment at Pivotal. I was speaking with Ms. Kiefer about that. I don't know that a release was signed because that hasn't been transferred over to the probation department yet, but he does report that he also has another Pivotal appointment set for October 2nd. So I do believe, even though he is a young man, that how he came before the court has had him grow up a little bit here, and he understands that he needs to get a handle on this because it's something he's going to be dealing with, every day. And I think that the tools that the sobriety court can offer would be a benefit to him. The information that can be gleaned from others in sobriety court. I think those experiences are ones that he could benefit from as well. So, Your Honor, we would respectfully ask, even though we're still awaiting that report, that he be considered as a sobriety court candidate. Thank you.
Ms. Kiefer, I'll hear from you first, and then we'll hear from Ms. Canfield. You spent a lot of time on this particular case, and we've discussed it. We are concerned about how young you are and whether you're ready and mature enough to do a sobriety court treatment program and ready to accept the fact that you can't drink. The other factor is this is your only way to get your driver's license for the next 5 years. Autumn, what's your thought here?
Well, we were here on the 2nd of September. Mr. Richards was sentenced in the other case. He did serve 3 days according to the jail roster. Worst we can do is fail. I have emailed Pivotal to see if I can get that assessment. If Mr. Richards failed to sign a release, if his appointment is on the 2nd, then he can sign that when he goes in. If he goes into sobriety court, I'll have it signed this afternoon, and send that to them.
We have two other guys in the program right now who kind of fit your profile. They're young, single men with a party lifestyle and a couple of drunk driving arrests in short order. We have another guy who was 24 now, who graduated the program, and he has done an outstanding job. Do you want to do sobriety court?
Yes, sir.
Ms. Canfield, what's your thought?
Your Honor, I understand Ms. Kiefer's concerns about whether or not he'd be willing or able to complete the program, given the fact that he doesn't seem to, at least when she spoke with him, understand completely that it doesn't mean drinking less or just drinking at home. It means no drinking. And you have to be ready for that because you're developing or already have a dependency on alcohol. And that's the concern with young people, men and women, who think that it's okay because it's fun and they can be around it and they think that they can consume a smaller amount or just not drive, and that's simply not the case. Under the circumstances, because he's here and he is willing to do the program, I think that is a step in the correct direction. So with hesitancy, I'm going to agree with the recommendation for the sobriety court. See if we can get some services underway with some of the other people in the program. I think their support and experiences may be able to get through to him to a larger degree when you're dealing with others who have the same alcohol dependency and convictions. Perhaps that wisdom can be imparted to Mr. Richards and he can benefit from that. The problem with just doing a straight jail sentence, I see, which normally under circumstances with two so close together, I would recommend, is that it doesn't give him any opportunity to rehabilitate or have treatment, which he desperately needs. So I will agree with the recommendation and ask that the court impose it with sobriety court.
One of the concerns we had is that you were on bond on the other one when you did this one, so we didn't even slow you down a bit. So we're gonna try to slow you down. And Autumn says the worst we can do is fail. If we're successful, you'll be better, we'll be better, everybody will be better. If we aren't successful, we can put you in jail. Which we could do now. Your attitude is good. We've got a couple guys in there, as I said, who are kind of the same profile, and Miss Canfield kind of touched on that. Maybe you can benefit from being around other people in your circumstance who are trying to turn it around. We just had a guy graduate. He did an outstanding job, excellent job. His son, who's about your age, got arrested for drunk driving while dad was in sobriety court. And his son called the dad and said, "Come get me. I just ran on into a cornfield." And he said, "Son, I can't help you." Sure, that was very hard for him. Now the son's taking his lumps. The gentleman you just saw was 44 years old and his blood alcohol was 0.388. You don't want to be that guy. Or you don't want to be the guy that we read about who died. We have 2 fatal accident cases set for felony tomorrow. So let's give it a try. I'm going to order 24-month probation. We just did some jail. I think she was going to defer all of this.
I wasn't originally, Your Honor, but now I will since that they were sentenced separately. He's done 3 days. So
Yes.
he can have his credit.
Or 30 days jail, credit 1, leaving 29 days deferred. There's actually 93 hanging over your head, but we're gonna do this expensive proposition. I'm gonna waive the fine because I just gave you one in the other case. $75 crime victims' rights fee, $50 state minimum fee. I'll make the screening fee 0 because she just did the other one. Attorney fee is $150 and the probation is $960. And they didn't, was there a police reimbursement, Ms. Canfield?
I did not see
We
one
couldn't find one
submitted.
either, but sometimes you guys have it and we didn't.
Let me just exit out of that screen. It doesn't look like one was requested at this point, Your Honor. It was a prompt.
All right. No drugs and no alcohol. Test as directed. Substance abuse counseling and treatment and sobriety court, and you're to sign a release. Our next session is next Tuesday, October 7th. You'll be there live in person. Where are you working right now?
Northrop Construction.
Oh, yes, we got several guys that are working construction. And it's problematic in that you might be at a job site out in Decatur somewhere, putting a roof on a house, and you got to go to sobriety court. Well, a lot of those guys have been zooming in from their car. But there's places to be. You got to do your testing at the day reporting center. You got to do your treatment. You got to go to support group, AA or Celebrate or other program. You got to meet with me every 2 weeks. Eventually, we may be able to get you an interlock so you can drive your car. Do you have a car?
Oh, yeah.
What is it?
It's a Cadillac.
All right. Pink Cadillac?
No, it's red.
Coffee colored Cadillac? All right. Your attitude, I can't ask for anything better, but I want you to go downstairs with Autumn. We'll get you plugged in. There's a lot to do and it's overwhelming at the start. What the guys often say is stick it out and you'll get it. You'll start to get it and it gets easier. All right. I didn't order any additional jail, which is somewhat unusual in this kind of circumstance. All right, you go downstairs with the probation officer and she'll get you plugged in.
Thank you, Your Honor.
Thank you. Angelique, it's very helpful to have you as our sobriety court prosecutor.
Oh, good. I'm glad.
Well, it is. We haven't had it in so long. We haven't had it since Mr. George was there. So you'll see him on the way in and then as we get into the program, and I just want you to know I appreciate it. All right, we'll be in recess.
And ladies and gentlemen, since we're live, I'll say thank you very much for hanging out with me tonight. It's been amazing. Chat's been awesome. I don't know what more to say. This is a unique thing. We don't do this every single night, but we are live. We are actually live tonight. We'll be back tomorrow with maybe more premieres. Who knows? We may go crazy and go live tomorrow too. It's all the same, right? Y'all, there was a Judge Simpson. It was crazy today. It'll be out later. You want to see it. But hey, thank you, Marty. Thank you, Coyote. Thank you, Violet. Thank you, Rhonda. Thank you, Mama. Thank you, Shiloh. Thank you, Tori. Here, Violet. Everybody who's been in chatting tonight. I do appreciate you. I appreciate you, every single one of you. We do these things every single night at 8 p.m. Central Time. That's 9 p.m. Eastern Time. Come on by and see us. If we're not live like this, then the chat's live, and we're all sitting here, you know, having fun, talking about stuff. Who knows? Maybe trading, you know, cooking recipes or something. Maybe talking about cases sometimes. Sometimes. Ladies and gentlemen, I'm your lone wolf Usul, and I'm done here for the evening. We have watched all the cases that I have, unless you want to spend the next 2 hours watching a Judge Simpson. 2.5 hours, actually. I don't think anybody's up for that. 2.5 hours of Judge Simpson. Nah. Time to say goodnight. I do appreciate all of you, and I'm gonna say goodnight once and for all. And y'all have a very good evening. I'm your lone wolf Usul. I'm your one and only curator for these here videos and this channel where we watch court cases all the time. Come on by and see us. Y'all have a good night. No, wait a second. Hold on. Time out. Let's have a real talk right now. Because I'm reading chat, and Rhonda said a thing. What just happened, bro? Bromiticus, I paused the song because, yeah, I'm talking. Because Rhonda said a thing. She said she's down. Is there anybody else that's down? Because you're down. You're down like a clown. You know, I'm just saying. I'm just saying, there is that possibility. I mean, I'm not gonna say all right. So Mama Wolfie, go to bed. Don't stay up. You can watch it later. I'll release it as a separate thing later. I'll do this live. Plus, I'll release it later where you can watch it in segments or something. Because ladies and gentlemen, welcome to the beginning of a new show. Starting at 2 hours and 30 minutes into the to the last show. So I'm going to let this sit here for just a second, and I'm reading chat. And as I read chat, I need everybody to say yay or nay. Yes, we go. I hit play. No, we say good night, and we have a good day. We have a good day. I mean, that's all there is to it, right? Yes, I see a yes. Rhonda, I think we know Rhonda's a yay. Rhonda is a yay. That's not even a debate. Not even a debate. I will bring the starting screen back up so everybody can see yays. Violet's a no. We got a no. We do have a no. Garvey, I'm going to hit play and go make coffee. That's what I'm going to do. So if this is what we're doing, I'm hitting play and I'm going to make coffee. Samantha, we are literally about to start a whole new stream, basically. We finished one stream, Samantha, and I'm taking a poll. It's kind of a verbal poll with the chat. We're kind of having a game here where I've stopped the music because somebody said we're up to watch another 2 hours of court with Judge Simpson in this really crazy case that happened today. So I'm here to play it, and that's exactly what we're
Court does call the case of Anderson versus Lyman. State your appearance, please.
Laura Anderson. Or Lyman Lyman.
All right, Miss Lyman, when the court says 9 o'clock, I mean 9 o'clock. We're waiting for you to appear at the courthouse.
Okay.
So that won't happen again, correct?
Yes.
All right. This is the date and time set for trial. Each side ready to go to trial?
Yes.
All right. Sanderson, you may proceed.
Should I stand there for or right here?
Stand
I wanna-
wherever
my
you
opening-
want, that you'll be picked up on a microphone.
I want to give my opening statement. And then I have one.
Go ahead. Do your opening statement.
Okay. Your Honor,
Ma'am, put the microphone back where it was. It will pick you up.
sorry about that. Your Honor, my name is Laura Anderson, and I am the plaintiff and owner of the property at issue. I am here seeking a judgment for $14,000.46, which includes unpaid rent, court costs, unpaid water bill, and damages in the amount of $2,866. Miss Armand Lyman read a false information on her rental application, including misrepresenting her residency to justify the decision to rent my home to her. This is not a typical landlord-tenant dispute. She has a documented history of property damage, unpaid rent, and disruptive behavior, as shown in the exhibits and testimony I will present. I want to acknowledge that I appreciate the court's efforts in landlord-tenant cases to maintain tenancy for individuals who might otherwise be homeless. However, this case is different because it involves actual property damage and destruction, not just homelessness. If the court allows Ms. Lyman to remain a tenant, I respectfully request safeguards to protect my home because this is the only way I will have access to my property. The defendant will not allow me into my home and does not communicate with me outside of the court. While the lease allows me access with a 24-hour notice, Ms. Lyman has denied me entry, making court order inspections necessary. Therefore, I request that the court order monthly inspections at a specific time each month so that these inspections are enforceable and I can return to court if Ms. Lyman fails to comply. Monthly property inspections with Mr. Ivory Clinton present to detect smoking inside the home. Inspections scheduled once per month on a Saturday at a specific time set by the court, preferably 10 or 11 a.m. During inspections, I request permission to take photos of the property condition. I request access to inspect the entire home, including the basement and garage. I will bring an HVAC filter to the inspection and replace it monthly as part of regular maintenance. Inspections will confirm that there are no unauthorized occupants, no further property damage, and no smoking inside the home. I asked the court to instruct Ms. Lyman to allow access to the home for myself and a licensed contractor on October 7th to repair cracks in the basement, scheduled to start between 8 and 10 a.m. and expected to last several hours. I am also respectfully requesting that the court return 2 zip drives in my possession. I did not present any video evidence in this trial, and these drives contain precious family memories. For this reason, I ask that these videos not be included as evidence. These methods are essential to prevent repetition of past destructive behavior, ensure compliance with lease terms and local laws, and allow me reasonable access to my property. I respectfully ask the court to grant judgment 46 cents and Ms. Lyman's leave tenant order
protective measures to safeguard my home. Thank you, Your Honor.
Ms. Wyman, opening statement.
Okay. So I have not been able to peacefully stay in the house. Every time I turn around, she's either down the street or have somebody watching me. So I would really like to be able to enjoy the home, which I haven't. I pay all this money to not be able to enjoy the home. I don't smoke, so there's no smoking happening on the property. There are no damages. And the judgment, that seems like a much, because she's including the rent that I had paid to you guys in escrow in the judgment. Also, I would like an addendum to the lease for my $750. That she said that she legally lied and said that she didn't know that she can put it as non-refundable because somebody else is suing her for the same $750. When I moved in May, I paid $3,300. It should have been prorated because I moved in on May 5th. So that should have been prorated $533 plus the extra $300 that's left over from the deposit. In June, I paid an extra $200. So I ended up going out the $500. In July and August, I paid the $3,000. The only month I owe is this month. So from
this month being September or
yes,
October?
I can pay that tomorrow. So only every month is $3,300. The extra money, me paying the 2 months for prorated the $530. The extra $300 from the deposit comes up to $1,033. So I figure that I should take that from the rent, and it should be $2,267.
That you owe.
Yes.
So I'm assuming we call you first witness. Is that going to be yourself or somebody?
Hey, should I stand there to question the witness? First, the witness stands there.
It's up to you. Where do you want to stand?
Oh, my witness.
Sir, please come forward and be sworn.
They spell your first and last name correct.
First name's right, did I do wrong? Fucking Q1.
Your Honor, may I give this to Mr. Clinton to reference?
I don't know what it is.
It's evidence pack number 4 that I've already.
No, that's not the way it's done.
Oh.
Question him and then.
Okay. Mr. Clinton, how long have you known the plaintiff, Miss Anderson? Yeah, can you hear, hon? How he has a hearing trouble.
Get him equipment so he can hear the questions.
Thank you, Mr. Clinton. Mr. Clinton, how long have you known me, the plaintiff, Miss Anderson? Okay. In your experience, how have you known me to maintain my home, its cleanliness, its floors, the overall condition? Almost perfect? Okay. Do you recall when I was preparing the home for sale in the spring of 2025? Okay. Do you recall the condition of the home when it was listed on the market in April 2025? Looking at the before and after photos in Exhibit 4, did you ever see a rear screen?
Exhibit 4 hasn't been admitted. I don't know.
I have, yes, sir. I gave them all to the clerk on.
It hasn't been admitted, ma'am.
The clerk, I came here on Friday and Ann, or it was Ann, she said she would give it to you. She gave it, I put it in a packet.
But it hasn't been admitted.
How do I?
Trial.
How do I admit it?
Ma'am, I can't tell you that.
Okay. So.
I don't know who took the photos. I don't know when they were taken. I don't know any of that about these purported photos.
Well, how can I get what I dropped off on Friday to you? So I thought you had them. I actually spent a lot of money to produce the color prints. It cost me over $20.
Ma'am, whether I have them or not doesn't mean that they've been admitted into trial. Who has to establish those photos and then attempt to try to have questioning regarding those photos.
Okay, I'll do that. Can I admit Exhibit 4 into court?
Ma'am, I don't know who, there's no testimony as to who took the photos.
The professional
what their photos are.
of my house, the professional photos of my house, and then I took the photos of the damages.
And you need to testify about the photos.
Okay. So what do you want me to say? Go over Exhibit 4 with you?
I just want you to do the trial, but I'm not going to have you admit things, and I don't know if they've been presented to.
Yeah. I sent her all the files, all the files to the defendant.
I don't know what those files are.
The exhibits. Can we? I spent a lot of money bringing the exhibits to court, and I dropped them off on Friday. She did a stamp. She put a stamp on them to give to you, and she said everything's fine. And so I thought you had the exhibits. I labeled them. I emailed them to you, but also printed them out. But I labeled them exhibits.
Maybe you're not understanding. You can send to the court whatever you like. It doesn't make them an exhibit in the trial.
So how do I send them to be an exhibit to the trial?
I am not here to assist necessarily either side in this trial. Until the court considers evidence in the trial, you need to properly admit it.
So how do I properly admit the evidence, sir?
I'm not here as your lawyer, ma'am. I'm here as a judge.
Okay. So you want me to just ask him the questions then? I'll ask him the questions. Do you ever, Mr. Clinton, do you ever remember seeing the rear screen door ripped?
No.
Do you ever remember oil stains in the driveway? Do you ever remember me mounting a security camera on the south end of the home?
No.
Do you ever recall the master bedroom blinds being broken? And the front door lock, it was never an automatic door lock. It was always a mechanical door lock, correct? Okay. Can you confirm for the court that the before photos accurately represent the condition of the property before Ms. Lyman took possession, May 5th, 2025?
Where did these photos come from?
They were photos I took when I was, after the home was prepared for sale.
Ma'am, you took the photos.
No, they were taken by a professional because they were actually put in the
then
MLS.
How's he going to establish that? You need the professional here.
The professional photos were taken, they were put in the MLS, and then I took the damage photos.
What did I just say? Who took the photos?
The professional photos, 2 people.
Oh.
2 people.
He did not take the photos.
No,
You didn't take these.
I took the after photos. The before photos were professional photos for the home to be in the.
My question.
Okay.
The photos that he just talked about, the witness did not take those.
No,
You did not take those.
no.
Then where's the testimony about who took the photos?
They were by a professional photographer who takes photos for listing a home in the real estate MLS.
Where are they?
He has a job. I can't afford to pay him to be here. And you don't allow Zoom testimony. So, I mean, I'm doing the best I can, sir. I don't have any money.
I tell you what. You did not make a request for that Zoom testimony.
I did.
And then
I
are you going to keep interrupting me? Because I'm not going to do this all day. The person that took the photos needs to testify as to those photos. Preliminarily.
I did not know that, sir. But if he could do Zoom.
That's not my issue. I'm telling you. Yes.
I requested Zoom for 4 other witnesses and I was denied because they live out of state.
Because this individual did not consent. You should have at least asked her.
She doesn't talk to me outside of court.
You know what? I am not here to solve the world's problems. Only the issue that's in front of me. Did you make the request of her to have these?
She doesn't, I sent an
Did
email.
you make the request?
No,
Okay.
but she does not talk
That's
to
an
me.
answer to my question.
He can at least attest to the fact that the home was in good shape before she took it
I
over.
think he already told me.
Okay, that's fine. Mr. Clinton, can you please confirm that the MLS photos are the same photos that accurately represented the pristine and spotless condition of the property presented to Ms. Lyman? The home was in pristine condition when it was presented to Ms. Lyman.
Yeah.
Okay. And can you confirm that the broken screen door, oil stains, changed front door lock, security camera, broken master bedroom blinds, all occurred after Miss Lyman took Tennessee?
Yes.
Clinton, how often were you at that property?
Before or now?
Before. Well, let's just ask this. How many times have you been to that property?
Or
How many times before Miss Lyman moved in?
I can tell you.
Before Miss Lyman moved in.
Oh, call 50 or 60, not more.
And you've been out to the property since?
So now,
For what purpose?
pick up the mail or
For who?
uh,
What's your relationship to Miss Anderson?
sorry, well, we've been friends about 20-some years.
What is the relationship now? Just friends? Go ahead.
Mr. Clinton, were you present in the district court on August 15th when Miss Gloria Vanderwell testified in front of Judge Washington regarding 6285 Maplehurst Drive?
It's hearsay. Don't answer the question.
Did you see photos showing 2 bathtubs with running water left?
Where? Did he see photos where?
In Exhibit 6 that show the damage she did to Miss Lyman did to the Maplehurst property. They were
To whose property?
to her prior residence. He's seen the damage to her prior residence.
Were you there and saw the damage? I'm not going to allow it.
Even though it was in court that it was presented?
What did I just say?
Okay. Well, I'm learning, sir. Forgive me. Did you see the final water bill from Ypsilanti Township showing a final water bill for the Maplehurst property of $3,153.69 during Miss Lyman's tenancy at 6285 Maplehurst.
Why am I talking about Maple?
I thought it showed evidence of damage to prior property.
I don't. Have you ever been to Maplehurst, sir? You know the owners of Maplehurst? Do you know anything about that property? Other than I mean, that was a bad question. Do you have personal knowledge of anything regarding that Maplehurst property?
Okay, so
I can't testify as to.
okay, I thought because he was at the court, I thought he could do that. So, okay, there's no further questions for Mr. Clinton.
Any cross-examination, Mr. Sloan? Any questions you have for him? No? Thank you, sir. You may step down.
And he's also Air Force, sir. I'm sorry, you're Army.
Other witnesses.
Miss Lyman?
Lyman, come on up. You may.
Okay, this is going to be questions about the lease. To Miss Lyman, which I have a copy here if she needs it, but rent, let's see here. Rent under your lease is due the 4th of each month, correct? Per line item number 41 of the lease. Yeah, but the 4th is it doesn't have the 5th. It has the 4th on line 41. I can show you. It doesn't have the 5th. It's due on the 4th. The lease provides only a 3-day grace period and imposes a $150 late fee on the 8th day, correct? It's line number 40, line number 4 on the lease. Isn't it true that you were late paying rent for July, August, and September? I know, but you were late on those days that you paid the rent. July, in fact, on the ledger, I can give the dates when you turned them in.
What?
On July, for July rent, you turned it in August 1st. For August rent, you turned that in September 2nd, and you still haven't turned September rent in. So wouldn't you agree that you've been late on paying rent all 3 months? Are you aware that partial rent payments are not accepted under this lease?
She said I can check it.
Partial meaning like you couldn't just pay half of it one day and half of it the other. It all has to be paid at one time. Are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th day of the month and file with the court on the 12th going forward, and you will be expected to pay court costs. If I have to bring you to court to get rent, if I file a 7-day notice.
Was that a question?
No, I'm making her,
Question?
no, I was making her aware of that.
You need to ask her a question.
Okay, are you aware that if rent and late fees are not paid, I plan to issue a 7-day notice on the 5th of the month and file it with the court on the 12th going forward? and you will be expected to pay the court cost.
What's the relevance?
That's just, it's a question just to
What's
make
the relevance of that question?
that it, going forward, if she still remains my tenant, I plan to be on top of it as far as rent. If it's not paid, I will issue a 7-day notice.
What bearing does that have with anything the court has to decide today?
Okay, sorry. Strike that one. Under your lease, only you, the named tenant, are permitted to reside in the home without my written consent, correct? Okay, who is currently living at 4259 Shandy Court? Isn't it true that your uncle and 3 children have been observed living at the property by several neighbors? Okay, line items number 19 and 9 and 19 on the lease. Did you change the locks on the home without my written consent? Without my written consent? Did I write something down? Okay. Are you aware the lease prohibits changing locks without the landlord's permission and expressly allows the landlord entry without notice in emergencies? Do you know that I'm able to go in emergencies? Fire, water? Okay. In an emergency such as water running continuously, fire, or a suspected medical emergency, do you expect me to break the locks to gain entry? Are you aware that my former tenant, Gabriella Anderson, died in Ypsilanti Township?
What's the relevance of that?
I have a history of a tenant dying in my property.
Why do I need to know that?
Because it shows why it's important to have access to a home. As a landlord, if somebody dies, I need to have access
Does
to
she
the home.
know that? And if she does, what's the relevance of that in whatever her answer is?
I'm making her aware that the reason why it's
This
important.
is not a proceeding for you to make her aware of things or what your expectations are.
Okay. I was explaining.
You don't have to answer the question.
Okay.
Go to
Okay.
your next one.
Okay. Will you allow my licensed contractor, Affordable Dry Basements, to enter on October 2nd to repair the basement crack? I sent an email to you at Armani Lyman.
So most likely didn't see it, but that's not a good day.
Well, I can.
She said they could come in the spring, so.
Yeah, but I don't want it to go through winter. I don't want it to go through winter. The crack is just getting worse, sir. I want to get it done before winter because
Are
they
you
can't.
going to ask a question?
I want to ask her when I can schedule Affordable Dry Basements to enter to do the repair in the basement. Are you aware that it won't pass certification with the crack in the basement? It won't. It's leaking now, sir. So we won't pass the certification.
Why are you talking? You were supposed to be asking questions.
Okay, when will you allow my licensed contractor to repair the crack in the basement? Okay, what month? So I can. Can I ask a question, sir? Of you? Because the crack is getting worse and it's damaging my property. It needs to be
That's a
repaired.
statement.
It needs to be repaired.
That's another statement. What's your question?
My question is, I need to, my lease states that I can go in and make repairs with a 24-hour notice. So she's going against my lease by not allowing me to go in.
Okay, once again, a statement. You asked, can I ask you a question?
So can I ask the court to enforce my lease? Can I ask the court to enforce my lease?
You can ask the court to do whatever you want. Whether they do it or not becomes a whole other issue.
Even though it's damaging my property. I'm just.
Next question.
Okay. Well, it was along with, that was, I'll go to the next one. Okay. Under the lease, you're responsible for paying all utilities, including water, electric, correct? Okay. Have you paid the water bill for May 5th through August 31st, totaling $1,471.87?
I'm sorry, say that again.
The water bill is in my name. I have worked something else within my name.
Okay, because, may I make a comment to the court? If the water bill, okay.
This is testimony.
Okay. Did you pay the DTE bill that was subject to shut off, notice dated on September 17th? Yeah, as a landlord, they sent me a shut off notice.
Oh, for Pete's sakes. Why do I keep getting comments?
Okay, the question was, did you pay the DTE bill that was subject to shut off?
Answer.
Did you paid it? Did you pay the electric bill? So the electric's off? Okay. This is the next question. Do you plan to keep the home above 50 degrees this winter as required by the lease? Okay. Are you aware that you will be held liable for any frozen pipe damage beyond your security deposit resulting from temperatures below freezing or winter shutoff? Huh? Thank you. Line number 18 of the lease, repairs due to tenant's negligence. Are you aware that repairs due to your negligence are your responsibility? Will you arrange for the repairs of the torn screen, broken blinds, torn down insulation and oil stains in the driveway by a professional contractor?
Last coordinated the following installation has been put up. The screen is on the checklist. The blinds will be fixed. And the oil stains are barely even visible.
But they're still there. So it will require.
Is that a question?
Well, so she.
Or are you just going to argue with her?
Okay. My next question was, if you do not hire your own licensed contractor, will you permit my contractor to complete the repairs and reimburse me? Okay. Are you aware that these repairs must be completed before the next Pittsfield Township rental inspection, May 26th, to maintain certification? Thank you. Inspections and smoke damage. Are you aware that smoking is prohibited in the lease? Okay. Will you permit monthly inspections by the landlord with a witness present so landlord can document the condition of the home, including photographs and checking for smoke odor? Are you aware in the lease it says that I am allowed to do inspections with a 24-hour notice? So you don't want to go abide by the lease?
That's she doesn't have to answer that.
Okay. Do you understand that if smoke odor is detected and smoke damage is documented, repainting and remediation of the entire home may be required at an estimated cost of approximately $10,000?
What? Really? Where does that come from?
3,000 square feet will cost.
Where does that come from?
I'm just making her aware about smoke damage.
Why?
Okay, sorry. Strike it.
Where
Strike it,
does
sir.
that come from?
I've been quoted $10,000 to paint that house.
By whom?
Contractor, because it's a large house and smoke will sink into the paint.
I don't know anybody named contractor.
Nicholas Blake, licensed contractor.
Is he here to testify?
No.
Then I don't want any questions about any quote he's given.
Okay.
That's hearsay.
Okay. Sorry,
Next
sir.
question.
Yes, sir. Nuisance and children, line item 20. Are there 3 children residing at the property? Okay. Were those children left unsupervised in the street on or about May 22nd, prompting a CPS call? They were supervised? I don't know if you'll allow this question, but do you understand that the lease prohibits public nuisance and requires you to supervise children? Cameras and alterations, line number 20 on the lease. Did you install an exterior camera without written consent of the landlord?
Also, the first quarter, you said you had no problems with cameras. So what's the problem?
I didn't authorize installation. I never said I didn't. No. I just said,
Yes, you did.
the prior court date, I said as a compromise, I would accept it, but I'm just going over what she violated. I thought we
Okay, so
wanted,
she installed cameras
Okay,
and
okay.
installed the security
that's
system.
all I wanted,
All
just
right.
get confirmation. Are you, okay, can I ask this question?
I don't know.
I know I'm upsetting you. I'm sorry,
You're
sir.
not upsetting me.
I'm not a
You're
lawyer.
wasting my time,
Okay.
but you're not upsetting.
Okay. Are you aware you will need to refill the holes and repair the siding damage by that occurred when you installed the camera? When you leave, you'll have to do those repairs, fill in those holes from the camera.
Under the terms of the lease, she has to restore the premises back to a reasonable condition as she got it. I think everybody knows that. Do you understand that, Ms. Lemon? Thank you.
Thank you,
Next
sir.
question.
I think I've already asked about smoking. Okay. And you don't, okay. Are you prohibit smoking? She knows that. Okay. Yard and maintenance. Are you responsible for mowing, trimming hedges, watering plants, and snow removal under the lease? Line item number 24.
Yes.
Okay. Have the hedges been trimmed as required by HOA rules? Do you plan on getting them trimmed so that I don't get a fine from the HOA?
Have you gotten a fine?
Not yet, but they've said.
Okay.
Okay. Vehicles. Did you have 2 inoperative and or unregistered vehicles on the property? Okay. Were 2 of those vehicles towed away? Okay. Did those vehicles cause oil stains in the driveway? Okay. Do you plan on hiring a professional contractor to remove these oil stains? Subletting and insurance. Are you currently living at the home by yourself? You already answered that.
Yes.
Okay. Have you sublet any part of the home to another person? Are you aware that subletting the home is prohibited without written consent? Do you currently maintain renter's insurance as required by the lease? On May 5th, 2025, rental application, you listed your current address as 9090 Arlington Drive, correct? Okay. At the time, you were actually residing at 6285 Maplehurst Drive, where eviction proceedings were pending, correct? You were residing somewhere else that you didn't put on the application as your current address. No, it said current.
Which be cool.
Because you were being evicted, I based my decision to rent to you based on 6285 Maplehurst. They started eviction proceedings in January of 25. I was not made aware of that when I rented my home to you. Did you disclose that the pending eviction of your true address to me before moving in? Did you disclose that address to me before moving?
Was she required to?
Yes, the application said, where's your current residence? So I could follow up with the landlord of that residence.
That was not your question.
You
asked her whether or not she disclosed an eviction.
Yeah.
On the application, does it indicate, have you been evicted?
Yes, there's a section in there, any prior evictions on the application.
All right. At the point in time she applies, has she been evicted?
There were eviction proceedings.
Is that what the question asks?
No, it says, have you been evicted?
Thank you.
Oh, sir,
So that case had not concluded, is that correct?
that's correct.
Okay, then if you're saying that she misled you, your question is bad,
Well, but
because it has been all this morning.
okay, but she didn't disclose where her
You want to
address
argue
was.
with me?
No, honey, I'm sorry.
She doesn't have to answer that question, or actually, she answered the question.
Okay. Are you aware your lease states that breach of the lease gives the landlord the right to repossession? Line item number 32. Are you willing to remedy the lease violations or return the property to me? Okay. Do you understand line item number 36 on the lease? Only written agreements signed by both parties are enforceable under the lease. So verbal doesn't mean anything. It's only written.
You answered that. Okay.
Okay. This is questions with regard to the lease application. Miss Lyman, are you aware that the phone number you listed on the lease application, 734-460-9043, is that correct? No, on the application you just gave me, in 2025, you have that number on the application. Okay. Are you aware that according to reverse lookup, that number is this number is registered to you, but I've never received a response when texting or calling you on this number?
So, okay. If she says yes to that, what's that mean?
Okay. Okay. Scratch that one. Okay. Isn't it true that the only way I have been able to communicate with you is through your mother, Joanna Lyman, at 734-465-8335?
Yes.
Okay. Please confirm, do you regularly monitor or respond to your phone you listed on your application? Well, I guess that would be no, because you.
Well, are you going to answer it, or are you going to let her
Okay.
answer?
Okay, sir. Sorry. Okay, so the number 734-465-8335 is the best number?
Yes.
Okay. Okay. On your application, you listed your current address as 9090 Arlington Drive, correct? Current address. Okay. Isn't it true that at the time you completed your application, you were not living at 9090 Arlington Drive, but at 6285 Maplehurst? But you were living at 6285 Maplehurst. Okay. Isn't it also true that you were being evicted from Maplehurst property owned by Miss Gloria Vanderwell, your former landlord? She's the owner of the property. Greg is her husband. Yeah, that was the person that was at the prior trial. Yeah. Okay. On your application, you stated that you were renting a room from your parents, Desmond Jones, at $500 a month, correct? Well, it's on the application. It says Desmond Jones, and you told me you were living with your parents. Okay. But on the application, it says you were living at 9090 Arlington and paying $500 a month to your family. That's what the application says.
Yes.
Okay. You also wrote that the reason you wanted to rent my home was to have a place of my own, correct? Okay. In reality, weren't you leasing your own home at 6285 and facing eviction for non-payment of rent and property damage? The question is because you falsified the application, so you committed.
That's a conclusion.
If she said her current address was 99.
That's a conclusion. Get to your next question.
Okay. Do you admit that the address you provided on your application was false? Do you understand that providing false information on rental application is considered fraud?
Well, still answer that. That's a legal conclusion you're at.
I've been doing my Google searches, sir, and this is what I come up.
Well, then bring Google.
Is she typing all this, sir? Was I
You know
given?
what?
I'm just asking.
You know what? You know what? I'll tell you what. I'm taking a break. You get your questions in order and you understand how they're going to address this. Am I clear?
Yes, sir.
Have a seat. You make step. Court is all of us.
You know, the court probably wants us to reach me.
You may be seated. Miss Lyman, why don't you come on back up? And continue your question.
Thank you, sir. Do you admit that the address you provided on your application was false as your current residence? Do you understand that providing false information on rental application is considered fraud?
You already asked that question.
Oh, I'm sorry, sir. I
Strike it.
forgot where I was. Was I given truthful information to conduct my due diligence as a landlord, or did I base my decision to rent you on falsified information?
She's not going to be able to answer that. That's in your mind.
Sorry, sir. Your driver's license issued in 24 showed 9090 Arlington Drive as your address, correct? You were actually living at 99 Arlington Drive when your driver's license was issued, or were you living at 6285 Maplehurst? Do you acknowledge that listing 9090 Arlington as your address misled me about your true living situation at the time? Do you understand that I relied on information you provided in your application when deciding to rent to you? Are you aware that had I known about your prior rental history of fraud, non-payment of rent, and property damage at Maplehurst, I would not have rented my home to you?
She can't answer that. That's you.
Okay. Would you agree that my decision to rent to you was based on information you provided that was not?
Can't answer that. That's you.
Okay.
As to the form of your question.
Ms. Lyman, are you aware that Mr. Diop Dimba has owned and lived in 9090 Arlington Drive, Superior Township, since December 21? You and your family rented the property from the previous owner prior to December 21, correct?
Rented what property?
9090 Arlington Drive.
All right, you can answer. Forward it to us.
No, you didn't rent it? After Mr. Demba purchased it, you did not live there, true? Okay. Your driver's license lists 9090. That's correct?
You already asked and answered. Don't answer.
That driver's license was issued July 16th, 2024, while you were living at 6285 Maplehurst Drive in Ypsilanti Township, correct?
Don't answer that. Asked and answered.
Did you have permission from Mr. Demba to use Arlington Drive on your driver's license or rental application? Okay. Did you use Arlington Drive to mislead me, the landlord, into renting my property to you?
Your previous address?
I asked for a current address on the application, not a previous. Did you knowingly provide false information to gain advantage in renting my home? Okay. Are you aware that using someone else's address without permission is considered fraud under Michigan law?
No, she can't answer that. You're asking for a legal conclusion.
Did you understand that this could lead to criminal or civil penalties?
Can't answer that.
Do you admit your use of Arlington Drive was unauthorized? Okay. So, Ms. Lyman, even though you were living at 6285 Maplehurst in Ypsilanti Township, your driver's license issued July 16, 24, and your rental application listed 9090 Arlington Drive, Superior Township, without permission to mislead me into renting my home, correct? Ms. Lyman, Ms. Lyman, can you explain why the following damages are present after you took occupancy? Broken master bedroom blinds, oil stains in driveway, broken rear screen door. We already know about changed front door locks and mounted exterior camera, but what about the broken master bedroom blinds, oil stains in the driveway, and broken rear screen door? Okay, so you're going to replace the blinds eventually, or? Okay, thank you. Are you aware that under paragraph 18 of your lease agreement, you were responsible for these repairs? Okay, I just, Ms. Lyman, your tenancy began on May 5th, 2025, correct? Are you aware that the property had a valid certificate of occupancy and issued May 2025 before you moved in? Do you understand that a certificate of compliance means the property passed all required inspections and met township standards at that time? Are you aware that of the email from Mr. Frank Daniels, which I forwarded to you, Ypsilanti Township Housing Inspector, stating that the torn screen, torn insulation now present?
Ypsilanti Township?
Pittsfield, I'm sorry, sir, Pittsfield Township. Torn screen and torn insulation would not have passed inspection May 2025. So based on the inspector's statements, those items were not present at the time of his certification, correct? So those damages occurred after you moved in. The screen door was not on the wood checklist. The screen door was not that screen door was not like that. That Mr. Daniels.
Is that a question?
Yeah, the question was damages occurred after you moved in. Because Mr. Daniels states that the screen door in that condition would not have passed inspection.
What's the question?
Proof of condition that we got.
What's the question?
The question is,
you keep making statements.
Therefore, the damage occurred after you moved in, correct? Because Mr. Daniels inspected the property and it passed. Then she moved in and he said it would not pass. For the screen door.
So what's the question?
Just her acknowledging that she'll repair it in due time.
She already said that
Okay.
she was going to do that.
'Cause we
I
won't-
mean, and if she doesn't, that's part of the reason you have a security deposit.
I know, but the problem is when we get the inspection next year, it won't pass with these items.
Okay, and then I don't know how you see into the future that way.
Okay, I'm just trying to cover all my bases, sir. Sorry.
We say that I never said that I would hear the screen door on the checklist.
The screen door was.
I
not on the
heard
check.
you.
So you're not going to repair this?
I'm off the screen door. If she says it's on the checklist and you're saying it's not on the checklist and there's damage to that, that's going to have to be dealt with at some other point. It's not to be dealt with here. She's answered the question about the screen door. Go on.
Okay. You signed a lease that includes section 18, which states that tenant is responsible for damages and repairs caused by tenant during your tenancy, correct?
That's asked and answered.
Okay. Are you aware that the torn insulation violates property maintenance code section 102.2? Are you aware that the torn screen violates property maintenance code section 304.14? Do you understand that the property cannot pass inspection next year, May 26, unless these repairs are made?
It's irrelevant. Irrelevant. Next question.
Okay. Do you want to maintain your tenancy at this property? Okay. Are you aware that to maintain tenancy, the property must be recertified May 26 and these repairs are required to pass?
Go ahead, answer that if you can. It's not going to matter to me.
Okay. So, Ms. Lyman, to summarize, the property passed inspection and received a certificate of compliance May 25. You moved in on May 5th, 25, and the torn screen insulation would not have passed inspection. They occurred after you moved in. They violate township codes, and under section 18 of your lease, you are
Is
responsible.
there a question?
Okay, Ms. Lyman. Okay, accountability and lease compliance. Ms. Lyman, do you see that as a tenant, you are responsible for ensuring that all occupants, including guests or family members, comply with lease terms and local laws? Do you see that having unlisted occupants and unsupervised children could put the property of the residents in your tenancy at risk?
How?
Unsupervised children?
Yes.
They were running in the street, sir, and the neighbors complained that they almost hit one.
Then how does that put her tenancy at risk?
Oh, I thought it.
You have children? Okay, so hold on. So I don't even understand where that question might even go. Benefit to the question.
There was a police report that kids were running around unsupervised and CPS got involved.
Okay.
And I provided that to the court.
And so what does it matter if they're not her kids?
Okay, I'm not a lawyer. I'm trying my best, sir.
I can see that you're not a lawyer. I gotta ask you a question. I don't know you're attempting to try to hold her responsible for kids that aren't hers, as we haven't even established our kids that are a guest of hers.
Okay, okay. Appreciate that, sir. Okay, Ms. Lyman, do you, I sent you a copy of the HOA vehicle policy for the neighborhood. Are you aware that the policy states that unregistered or inoperative vehicles are not permitted on the property? No, I'm just.
Are there vehicles on the property?
No. This is.
Then why?
Okay.
Why
Okay.
are we dealing with this?
Okay. Okay. And you said it's hearsay about Maplehurst. So this next exhibit was all about Maplehurst. So you're saying that that's hearsay?
Ma'am, I don't even know what you're talking about.
Her prior residence. That was this next section. The damages to her prior residence. And that's
the damages to her prior residence. I don't know why that would be relevant to me. And I don't also understand that I don't even understand how you're getting that in.
Well, I just thought showing a history of destruction is relevant to my house and me being concerned. It shows why I'm concerned about my property. I'm not just concerned for just to be concerned. I have a reason to be concerned about my property. That's all. I'm just, this is my $570,000 baby. I care about my home.
Anything else?
No. So section 6 is docket. the there. So that's it for questions. I wanted to go over section. I had something for the court, but I'm done with asking questions of Ms. Lyman.
All right. Ms. Lyman, you'll have an opportunity to testify. You may step down. Any other witnesses for the plaintiff?
No, sir.
All right, here's what I'm going to do. Ms. Lyman, prior to your opening your case, should you decide to give one, court's going to stand in recess and it will go ahead.
Do I sit down, sir?
Pardon?
Do I sit down, sir?
You can sit down if you want.
Okay, well, you're the boss.
I know. You ought to remember that.
I was going to wear a hat. I love Judge Simpson.
Here's what I'm going to do. I'm going to break for lunch. It's a little bit early, but I thought we might get somewhere this morning. I'm going to break for lunch. We'll reconvene at 1:00. And then if there are no other witnesses for the plaintiff, then we'll go to defense's case at that point in time. All right? 1:00. Not 1:30. 1:00. Okay? Thank you. Court stands in. I'll just stand and be sworn.
Or take a seat, raise your right hand. Do you solemnly swear to affirm the testimony? State your first and last name. Record, please.
Go ahead.
Is it true that you told me Ivory Clinton was your domestic partner? Is it true that you have been showing outsiders pictures of me containing my personal information? Is it true that you gave me verbal consent that I could get my $750 decline deposit back?
If the house is in that you decided.
Is it true that a prior tenant is also suing you for their $750 decline deposit? May I get may I get a written addendum of me getting my $750 decline deposit back?
No.
Why not?
If you leave it the same condition as I got it. If the city's name lane, that's gonna depend on how.
You said verbal consent doesn't matter, so I'm asking you, can I get written?
Deposit back if it's not clean. If it's clean, then I put it back. It has to be clean.
May you write that I can get my $750 deposit back?
If it's clean. Same condition, like floors are clean.
Can I just stop here? The $750 is listed as non-refundable, but you are indicating that it's refundable provided the conditions are met.
To my satisfaction.
Well, ma'am, is that what you're saying? That is not what you're saying? You're saying that it's still non-refundable?
It's dependent upon conditions.
Understand what I'm saying. At this point,
If I
you want to know what? You interrupt me, we're going to have a real issue. There was the notion that the 750 was non-refundable, meaning it didn't matter what Ms. Lyman did. What I'm hearing at this point is that it is refundable. The conditions of that refund will wait to some other point in time, and there might be further litigation regarding it.
Yes, sir.
Is that what I'm hearing? Ms. Anderson?
That is conditional, the sun,
I don't know what that means.
if it's left clean, like the toilets are clean, the bathroom.
I understand something, what I'm saying. The cleaning deposit, if it is non-refundable, which would create some other problems, that means irrespective of what it looks like, or what Miss Lyman does, the $750 does not come back. A refundable cleaning deposit means that I have the $750 and that $750 would be returned provided it is left in a clean condition.
The same condition I gave to her, meaning I hire.
Ma'am, I'm telling you what. Your interpretation of landlord-tenant law is going to get you in trouble. I think I've got it, Miss Lyman. You can go on to your next subject matter.
Is it true that I have not been able to enjoy my home due to you continuously harassing me?
No.
Is it true that you have the neighbors watching my home? Is that not what you stated inside text messages? Okay.
You did not say that you had people watching your home, Miss Anderson.
And did I say it's watching the home?
Let me just ask this. Did you tell Miss Lyman that you had people watching the house?
Ever since the incident with,
Not my question. It's not a qualified answer. That's a yes or a no. Then why did you under oath just tell her no?
well, they're currently not watching.
Well, that's not what she asked you. Why are you changing the answer that you just gave to Miss Lyman? No, I want to know why you changed it. She asked you the question. You told her no. I asked you the question. You told me yes, you said it.
Okay, I guess right now they're not looking before they were.
Oh, that is not what she asked. Go ahead, Miss Lyman.
Okay. Is it true that you have parked down the street stalking the house
I was trying to get evidence or
and popping up on places where I have been? Is it true not only do you talk about me through text messages, you CC other people in my email that has nothing to do with them tarnishing my name?
every all the witnesses who are told me things I tried to do them. But I'm not trying to.
What does that mean? What do you mean their emails?
Like she emails a whole lot of stuff and put people from the neighborhood that I don't even know or people that I never met in the emails of her saying certain stuff to me and falsified information on me.
Miss Anderson, do you do that?
I could include the neighbor, yes.
About Miss Lyman?
Yeah.
Why?
Because they're telling me they're concerned about kids right now. And
Was it only about the kids?
No, in email she has stated false things like crack pipes, that there's a rapist in the home, different stuff like that.
Hold it. And I'm just going to remind you, you're under oath,
yes.
Under penalty of perjury. Did you say things that directly indicate that there may be drug use
yes.
and or a rapist in the home?
I only looked up this. Her London. She had criminal history.
You emailed Miss Lyman with her neighbors while she's renting,
They were saying
indicating that there was drug use, particularly hard drug use, like crack, and that there was a rapist at the home.
I said potential somebody with a criminal history.
Did you say potential?
I said, is this Mr. Lyman, who was named Augustus Lyman, who lives there, who has an extensive criminal?
Why?
Because I wanted to alert the neighbors. So
Alert them of what?
if I don't know who's living there. I didn't do a criminal background check on this person, and so I had to look it up online through IPN. And this particular uncle had a rap sheet. And
Was the address listed? Miss Lyman's address?
No, but I didn't.
Fine, but was the address of that individual list? Was it Miss Lyman's address? I don't care what you were told. Was the address when you looked it up? Was that Miss Lyman's address?
Miss Lyman's address. It wasn't under Miss Lyman's address. It was at the uncle. I looked up the uncle.
I just want to state that is not my uncle.
When you look up, if it is a sex offender, you will have an address that they are registered.
It wasn't.
Was he registered to that address?
A sex offender. It said attempted sexual assault under Augustus Lyman. He had that when I looked him up online. He had a big round.
Oh my God.
So.
And you sent that to Miss Lyman's neighbor.
Because they were concerned who was living there and what's going on.
What's the racist?
All right.
Fine.
Please don't.
All right, that's good. Yeah, we're gonna do. Find it, please. We're back on the record in the case of Anderson versus Lyman. Ms. Lyman, you may continue.
Is it true that you gave me verbal consent to get ADT?
I gave verbal consent, yes, but that was not on the honest. Now, original law was changed. That was for sensors in the inside. It's not told about 4 months.
Is it true when we first started going to court that June rent was already paid?
June rent was paid late, but it was paid, yes.
Is it true that you have called the Pittsfield Township Police Department on multiple occasions presenting falsified information?
And you and I'm concerned about what's going on, all that is you don't respond.
So are you saying
what? You call her, she doesn't respond, and you call the police.
I text her, just wanting to see my property and not having it respond from person. Is that, I'm not able to see.
You call her, text her, whatever. You don't get a response, whether she's choosing to or not, and you call the police. And what do the police say? I mean, what do you say to the police? Oh, for Pete's sakes.
I just want to state, not only is it a wellness check, when the police come, they had told me she must have something against you they don't be feeling like coming out because it's always something and they say it comes from her.
Go ahead.
Is it true on multiple occasions I asked you to stop sharing my personal information?
You said don't include other people in emails, yeah.
Is it true on multiple occasions that I asked you to stop sharing my personal information? Then why do you still do it?
And involved. Always involved with it. Like if involved people hurt, I still get involved.
Is it true that you told me that you have a multiple personality disorder along with other mental issues?
That's like that. I don't, you just.
I was asking.
Just
Is that the
stop. Stop. She doesn't have to answer that question. Go to your next question.
Is it true that I treat you with respect and all you do is disrespect me? Do you feel you know personal boundaries?
You don't respond on that, so I don't know.
Is it true that you're going through financial hardship? Is it true that you have stated in an email that you will pay the water bill and that I could reimburse you?
That's how I want to get judged. So any article was one article with this. I think if I'm getting judged, you really listen.
But if you're going through financial hardship, how would you pay the water bill?
Someone has to pay it. I'll do it alone. I have, a borrow with someone. Because otherwise, it doesn't get paid. Goes up and down.
So what are your next question?
Is it true when we met back in May of 2025, you pretended that you were a realtor and not the owner yourself? Is it true that you stated that the crack could be fixed in spring of 2026?
It can be fixed. Yes, it can be fixed in the spring.
Is it true in May of 2025, I paid $3,300?
You paid May rent? Yes.
Is it true that I paid $3,300 in June?
Yes, paid it.
Is it true that July and August rent is in escrow?
Yes, later. They're in escrow all late.
When I paid the rent back in May of 2025, is it true that it should have been prorated $553 since I moved in after
Let
the
her
first?
finish the question before you respond.
No, our tenant fee starts on April through May 4th of about 27, which means that your rent is due on the 4th. Your rent is due on the 4th. And your tenancy, that's how we did not leave. You're right prior to the first day of the month.
I was asking, since it was after the first, should it have been prorated $550?
Starting on.
Your answer to that is no. Go ahead, ma'am.
Do you know Marcus Escano?
That's zero.
You'll answer the question.
Is it true that he is suing you for $750?
Ma'am, you are not going to interrupt the question. Go ahead and ask your question.
Is it true that he is suing you for $750, which is the same amount as the cleaning fee?
You can answer the question. You don't know? You don't know? Is that your answer to the court? Because I'm directing you to answer the question. That's not the question. Is he suing you for the $750?
I'm not aware of that, but.
Go ahead, Ms. Lemon.
Are you aware of the bailiff that had came on behalf of Marcus Escano to the property and was on the phone with you?
Somebody called me and I did work, so
Let me ask this. This Marcus Toscano and the $750, has he sued you? Was there somebody appearing at the property regarding a dispute between you?
I would. Oh, someone called me.
Okay, all right. Somebody, you know what? You can play multiple games or not. Look it up. Hmm?
Nice.
Do you know how to spell Toscano?
His name is Lacano.
Okay. Go on with your next question while we look at it.
Okay. Is it true that you made Ivory Clinton block my driveway on July 1st of 2025? That was during the inspection. What if I told you I have video evidence of you having him do that? Okay.
You have video of him blocking the driveway?
She blocked the driveway on July 21st during the inspection, and it was on video. I can see if I can find the video where she told him to pull up and block the driveway.
Hold on. You think you have video of that?
Yes.
All right. Go ahead. Next question.
Is it true that you told me that the $600 custom blinds are not custom and that I can just take them down and present them at Lowe's?
Look at the manufacturer blinds and get the same manufacturer blinds so that they match.
Yeah. What if I told you the last time we were here in the back room that I have evidence of you stating that I can just take them to Lowe's and that they're not custom?
Be the same one. So they got a back.
That is not what I asked. I said, what if I told you that I have evidence of us in the back room and you say that I can just take them down and show them to Lowe's?
Yes, same time.
Is it true that not only have you been harassing me, you have had another attorney harassing me whose name is James Fink? What if I have you on voice recording stating stuff that he told you? Then why do you CC him in all our emails?
Because he's related to this attorney for lawyer then.
Why did you say you didn't know James Fink?
James Fink is known as an attorney for a lawyer then. Not mine.
What if I told you that I have a screenshot of you during Zoom asking who he is?
He's the attorney, but it's not mine. I never hired James Fink.
Why do you associate?
Next question.
Okay, my last question is it true that you told me if I keep ignoring you that I might end up like your prior attendant, Gabrielle Anderson, who is dead?
She died in my house, and I her couple died in my house. She did die in my house. She had a heart attack.
I'm asking, is it true that you told me that I could end up like her if I don't reply to you?
No, it's not. That's
Do you have that in writing?
Yes.
Pardon? Was that
She
a
said it in a text message. I have printed out.
Do you have a copy of that text message?
I have the copies of the text messages, yes, but I don't have them in the room with me right now.
And your understanding of that text message is, she said, if you don't respond to me, you could wind up like a tenant that is now just.
Yeah, she told me she's threatened me on multiple occasions.
I'm say to that. I never prayer.
Miss Anderson, stop. Go ahead, next question.
That's it. That's all the questions that I have. I also want to say that I do have pictures of the property
Hang
that I.
hang on.
Okay.
Paragraph 27 of your lease. Do you believe that if it's true that you contacted her neighbors, that there was the blocking of the driveway, that there was, if true, an implicit threat regarding Miss Lyman's death, and that you're constantly going to the premises has interfered with her peaceful and use of the premises, which you coveted it in that lease to provide under paragraph 27?
I haven't been to the house probably months. I think I maybe driven by. Not very often. I haven't probably driven by once, but I had not been to the house in a long time. Ever since the incident was the police coming to the house, and I was just concerned about.
Read paragraph 27. Particularly the second sentence.
Okay. I'm giving her peaceful enjoyment. I'm not over there.
You don't think in any way you've interfered with her peaceful enjoyment of the premises?
I've been concerned about the house, but maybe if she was just communicating, I wouldn't be so concerned about the house.
What do you think her legal obligation to talk to you is?
Well, she won't get me out.
What do you think her legal obligation to talk to you is?
Since she's living in my house, I think I have some right to have communication who's living in my house, just so I can know the status of things. And I have some right. And she's the only one.
I didn't ask that. Does she have a right not to say anything to you?
So she has the right not to say anything to me, but how do I find out about the house if I don't find out about it? Since I don't have access to it.
Do you think she has the right not to say anything?
I think she should at least communicate, or if she doesn't want to.
All right, Miss Anderson, you keep going on with these long convoluted answers. Yes or no? Do you believe that Miss Lyman, tenant or no tenant, has a right not to talk to you?
I don't think so.
So you think she has to talk to you?
No, basis just with regard to.
Under what legal premise do you believe that exists?
In the lease, it says that I have a right to. Number 18. It's we're 19 landlord's right to land for landlord's eating. Services that need time. Very charged to bring it. And any renewal thereafter, 20 bars of tenant. For the purpose of starting premises and all buildings improvements thereon to protect and make various operations and show standard renters traditions.
I read it. You don't have to read it. You can scan it and tell me where in that provision it makes Miss Lyman talk to you.
Judge, I understand she doesn't have.
Tell me in that provision, is there anything about that she has to talk?
Well, it says landlord must notify tenant. How do I notify her?
Like if I want to look at the property on short notice, how do I make that happen without?
Is there anything in that provision that requires Miss Lyman to talk to you?
That's not. I just don't know how.
Is there anything in that lease that requires her to talk to you? Then why is it throughout this entire proceeding, and based upon the testimony of Ms. Lyman, as well as what were the premise of some of her questions, are you forcing her or attempting to force her to talk to you? Then why are you trying to force her to do so? I didn't ask that. Why were you forcing her to do so?
Person, and I always say that Stacy is all like so me wanting to talk to her is just part of my normal way of trying to resolve.
Has she told you on repeated occasions she doesn't want to talk to you?
She doesn't.
I didn't ask that. Has she told you on repeated occasions that she doesn't want to talk to you?
Here she does. She doesn't say she says bad want to talk to you. She just says she don't like. She doesn't like it.
Why do you then, when she expresses that, do you continue to try to force her to talk to you?
Okay. Private.
Yes, Miss Laura.
I just want to say that I never told her that I didn't like her. That never came out my mouth. You never met my mom.
But they don't want to talk to you. You can't force them to do it.
I agree. I'm sorry. It's just. Sorry.
Why would you indicate to the neighbors that there's crack use in the house?
When I went in the house, I thought I saw like a crack I found out. That's what I observed when I was when I was in the house. I put my.
When was this?
It's been a while. I basically documented what I observed.
Okay, let's say you document what you. Why do you feel a compulsion to send that to the neighbor?
No, I sent the neighbors the information to know about living there. Concerned that this uncle was living there, and when I did a background check, it looked like we had history, and I thought I was just I was trying to help you.
Tell me each and every fact that leads you to the conclusion that that person was living.
The neighbors told me stranger that they showed up. There was an uncle, and when the uncle and the kid were moving in, they told the neighbor that they were an uncle and the kids moving in. And
how did you know his name?
because I looked it up, I did a search, and I did a.
How do you know that the name that you looked up and this person that you purport was supposedly moving in was the same person?
Based on the physical description of who the neighbors indicated it was the uncle, and I looked up her. I kind of got her family tree nailed out. Her grandma and her mom. You know
what?
I figured out.
Why would you do that?
Because I did pretty background checks.
Why would you do that? Have you ever, with another tenant, mapped out their family tree?
I was trying to find out who this uncle was because I was concerned with the neighbors. But the little kids running around the neighbors there.
You do understand that if you're renting property, that the tenant doesn't become your indentured servant and or slave.
Yes, sir.
And that you can't force them to do certain things that they've not contracted to do. You understand that, don't you? You understand that because they're a tenant, you don't get the right to disparage their reputation with the neighbors? Do you understand that?
Listen, Armand, what I was concerned about. I understand though, maybe I understand that I shouldn't be concerned, but I was concerned because I was just.
I didn't say that. You could be as concerned as you want. Do you understand that you're not permitted to disparage her reputation that way? You understand that if you see or purport to see something that would be drug use like crack cocaine use, that you don't have the right to then become, I guess, the judge of what that is, what you think it is, and draw a conclusion and then besmirch her reputation by sending that to the neighbors? You understand that you don't have a right to do that? Don't okay me. Answer my question. Do you understand? Then why did you do it?
Concerned, I didn't know what to do. I was concerned about the little kids around here. In my house.
Were these little kids smoking crack? I mean, why were you tying that to the kids?
Is my crack on crack?
Then why would you tell the neighbors it is? If you're not sure yourself, why would you tell them that?
I was not telling
You didn't say anything about a crack?
what.
Did you?
I know.
Well, you better remember right about now, Miss Anderson. You have a very convenient memory. Did you tell any of the neighbors or intimate to any of the neighbors that there was crack being smoked in that house? Not an answer to my question. Listen closely. Did you tell any of the neighbors or intimate to any of those neighbors that they were smoking crack in that house?
When I did Google search on Scout.
I didn't. There's no question. Quit talking. What months are you claiming are owed?
Just this month is old.
Okay. What months are you claiming are owed?
July, August, September. Plus the water bill that hires are paid. $140 third by 900 cents. I called the township report.
I didn't ask you that. What months? Listen to my question. What months are you claiming she hasn't paid?
July, and August are in escrow, and we're waiting on September. So September is the only one that's not in escrow.
So as she indicated at the very, if she puts that in, she's paid in full.
Not utilities and not forecast.
She's paid in full for rent.
Yeah, but she still has the late fee. You are authorized on July 11th, authorized, under it's like on July 11th.
Water bill. Where's there a copy of the water bill?
Can I get some?
Yes.
Thanks.
And leave that lease on the stand.
Do you want me to come back up?
Yes. Ms. Lyman needs to see anything that's being presented to me. Ms. Lyman, you indicated that you have been in contact with Pittsfield Township regarding the water bill.
Yes.
And have you arranged payment of that water?
Yes, I have already.
Yes, Ms. Anderson.
Spoke with Bill Township supervisor. He indicated that they have not worked out one of the water bill just an hour ago. I spoke with
Do you know who you spoke with?
No, I don't. They just told me that we could start a payment plan up.
Pardon?
They told me that I can start a payment plan up starting next next month.
Okay, who told you that?
Someone from the water department.
How much is the current bill?
So $1,127.02 that I have already paid prior to our bill, which showed me for her part of it. Under my already department. Was the 1.393.
So you,
I paid that already.
have you paid the water bill?
Have I paid? No.
No, not you. Ms. Anderson, you haven't paid this water bill?
I water made.
Give me the copy of the lease that I. So the only thing, Ms. Anderson, that you paid on this water bill is the $143.93.
Yes. I can pay the rest today.
Ma'am, I didn't ask you that. Just want to be clear. You did not. You haven't set up a payment plan.
Yes, I haven't physically set up making any payments.
Pardon?
I haven't made any payments, no. I was just told that I could do a payment plan next month, starting next month.
October.
Yes.
And is there a monthly amount on that?
They didn't say yet.
Pardon?
They didn't tell me yet. Still trying to work everything out.
Anderson, how many times have you sent Ms. Lyman a notice to quit?
I believe she's fine.
You have never sent her a notice to quit for the collection of rent.
The 30 days that I sent was because of the fraud. And it included no rent in that. It was for fraud and not paying the rent. At the time she was late on paying rent. So
how many times have you sent per the rent, or a notice to quit for non-payment of rent.
I think I did do 70 notes.
Yes.
No, I didn't do 70 or I did 30.
Have you ever sent Miss Lyman a 7-day notice?
No. It's 30.
How did you calculate the late fee?
Based on Google AI, 5% is the industry standard, so $150 3-day grace period is considered within the realm.
In Michigan?
It said when you because yes, 5% is the industry standard of a rent amount. Put it at 165, so I think 150 is fair. And that's
What do you think the purpose of the late fee is?
to try to encourage time payments and also
It can't be liquidated damages.
well,
It has to somehow or another be related to your efforts to collect
like,
rent.
drive all the way right and come here, and that is gas on. Gas isn't cheap. My time, you have to spend days here. I think I should work here. I just wanted to pay rent. I mean, I honestly.
I don't think there was a question. Let's go to the application. When she filled out the application prior to renting, did you check any parts of that application to verify any of the information?
Yes, the number that's no longer working is supposed to be her landlord, Desmond Jones, that,
Did you get a response from this Desmond Jones?
no, but I thought it was her parents, so I, she's living with her parents at 99 Arlington, so I thought, okay, I didn't, she didn't tell me.
Did you get a response from Desmond Jones? What else did you attempt to verify?
Well, since she was living with her parents, she, being honest, she's living, she paid $500.
Let me try this again. Did you attempt to verify any of the information that is on this application?
Well, the application showed me her pay stubs, so I knew everything was through a legitimate company, rent free. And they verify information like that, so I saw the board pay stubs, so I assumed that's where she works. The only thing normally I would have also done is talk to the current landlord, but because it was her father, supposedly or her parents, I thought, I guess I don't need to document that never didn't work, and so I just didn't pursue that, talking to the current landlord. I didn't know that it was the other thing with the landlord. The Vanderbilts with the landlord, and I should know this law. She would have definitely steered me away, she said.
So just so that I'm clear, if Miss Lyman would talk to you, let you just come into her premises illegally as you requested, would we even be here? Okay, that's what my problem. The reason that we're here, is it not, is because she won't talk to you.
I'm concerned about
There has been nothing detrimental to that application to you. Is there?
Sir,
Is there anything that has been detrimental to you?
I have lost sleep over this, sir.
Okay, fine. We all lose sleep. Is there anything referenced to tenants that has been detrimental based upon your reliance on that application?
I'm worried about my, sir. If she does damage to my property, it's gonna be well beyond her $5,000 earnings. It's well beyond that. And I worry, how am I gonna recoup? How am I gonna recover? I just wanna sleep at night and know my property is safe. That's all I want. I like this line. I just wanna know.
So, ma'am, can you answer my question? What in that application have you relied upon to your detriment?
The parents are like that. So I felt okay. I thought, oh, when college to be a nurse, first four, I really thought.
Okay, I'll try the question again, and even if you want to ramble on. What did you rely upon to your detriment in that application and renting to Miss Lyon?
For my was being evicted at her time. If I know that, I would have rent. It's like.
And you did not do a search regarding Miss Lyon?
Didn't about this application is rent free with you. Company for background checks. And I didn't see any evictions. There was no evictions on the report. So I thought, okay.
So they didn't pick up on it because there was no eviction. She might have been in court, but there was no eviction. What did she put on there that is fraudulent in your mind?
Her current address.
Why would that not have been her current residence if she were in the process of an eviction?
Just living on makeovers. Her current address.
And you relied upon that. Did you do any other searches, anything regarding Miss Lyman prior to renting? So you took what she said in the application, put it through to a company, and relied upon that. So in point of fact, you didn't necessarily rely upon what Ms. Lyman said. You relied upon what the company gave you back.
But yeah, the company. And what she can wrote, no, it wasn't just the company, sir. There's also she can wrote. So her current address, 99 her.
But you took the information that she gave you, gave it to a company, they ran it, and that's what you relied upon to rent.
Those things. That was firm. Yes, sir. Yes. Ultimately, you're the judge. You're right. So I'm not arguing.
Well, I'm asking a question, ma'am.
It's not what's fair. Whatever you think is fair, I'm going with whatever.
Ma'am, I just asked a question. You didn't rely upon the application. In fact, you relied upon what this other company had reported back. Right?
Yeah, they said no evictions, and they said
okay.
They also had two addresses. It was the 99 Arlington and a PO box. They did not show the Mapleburst on their search.
And I'm going to try again. And that's what you relied upon to do the search. I know What does that company require that you give them to do their search?
I think they charge us like $39.
They charged me 50.
And what information is submitted to them?
License, ready for pay stubs. Whatever she puts in the, I sent. I never had to sign.
This is a company that you use, and it then comes back and tells you this person is okay to rent.
I mean, they said her credit score's low, and I, she had student debt, and they're, not perfect, and I don't expect them to be perfect. But I didn't see any evictions. I didn't see any huge red flags. Yes, sir. Yes, sir. Yes, sir.
So that's what you relied upon to rent to her.
Yes.
Not the application that been flaunted around here. It was the report back from this company.
I don't want to make you angry, so whatever you want.
Ma'am, I am not angry, and don't try that game with me. If I get angry, you are certainly gonna know.
All right.
She typed in information to a company. They came back, gave you a report, such as a credit score, and blah, blah, blah. Can you point to the provision in the lease that incorporates the application into that lease? There isn't one, is there?
That's just what I used to, decide on.
If the application is not incorporated into the lease, then how do you evict her for what you say is a project?
At this point, I'm asking. That's in the rent. She said,
You filed a termination case to evict her.
So fair to this whole thing, so. I just want to get the rent and have somehow see my house. That's all. Somehow make sure my house is okay.
Well, I don't know how you're going to see the latter of that, because at this point, I'll be honest with you, I think you've been harassing her to the point that you've interfered with her quiet enjoyment to the premises. And she may be entitled to damages for that. I haven't made a final decision on that, but I'm just going to tell you, you can't go around, rent to somebody and say, and it's one, you can't then go around and just say they're a crackhead. You might say, oh, and think to yourself, gee, Miss Lyman looks like a crackhead. I'm just saying that for the purposes of this example. I'm not saying that about you, Miss Lyman, but you might say she's got sex offenders living with her. You might say all of that stuff. It becomes a whole different issue when you begin to disseminate it to other people. And maybe you don't get this, but with regard to the alleged sex offender, I have no idea if he is or not. There's a whole registry regarding. They're required to give their current address.
I'm just concerned, sir. I'm sorry. There's a lot of children.
It doesn't matter whether you're concerned. I could be concerned about whoever out there. I don't just go around saying to people, well, they must be a rapist. Oh, somebody's gonna lose. I'm gonna tell you that right now. It keeps up at this rate. But I'm gonna tell you what. Ms. Lyman, was there any other questions you had?
No, that's really it. I did wanted to say that I do have physical photos that I can admit of the property.
Well, let's do it this way. And correct me if I'm. But Miss Anderson, otherwise I'm going to need the text messages. But you told or intimated to the neighbors that there was crack use at that house.
I just said I saw crack.
That's all you said? Do you have, is that what's said on the text message?
I believe, I'm not sure if she CC'd the court in it, but it had like multiple messages with her and other people and stuff like that as well. Saying that it was a rapist in the home, and then people were like, that it was a
ma'am. Stop. Go ahead.
That it was a sex offender in the home, and then she had people like, what is wrong with her? Oh, you need to get her gone, just different stuff like that. She has sent emails with the photos of that, yes.
Well, at this point, I'm not going to need the copies. Anything else?
Nope, that is pretty much it. And just the written thing that about my deposit of the $750, that's it.
Anderson, anything else from you?
I did look up the records for her uncle, and it did say.
Okay, did it give an address? Did it give an address? So how do you tell the people around there that he's living there?
I just want to say the person that she keeps claiming that's my uncle, that's not my uncle. 2 different skin colors is what she's going by. But
yeah, what?
On
why do you keep interrupting?
The person that she's saying is my uncle is not my uncle. She's going off of the police report, but it listed 2 different appearances, and that's all I had to say. She just searched my name up and just tied that to me. She said that in the email as well.
I want to understand that.
She said she searched my name up and it said
your name.
Yes, my first and last name. And she said that Google or whatever she searched up in said that he was my uncle.
Is it your uncle?
No.
So this person she's talking about is not related to you.
That's not my uncle, no.
He's related.
Is he related to you?
Yes.
What is he?
A cousin.
A cousin?
Yes.
Okay.
Has he ever been at the property? No, if that's what I'm about to say.
So, okay. Just so that I'm clear, the person is a cousin of yours.
Yes.
Correct?
Yes.
And that cousin of yours, the one that may have this conviction, has never been to the property.
Correct.
So, Miss Anderson, you found somebody who was related to her. Do you have any personal knowledge that that person had been at that property?
Neighbor
Facebook.
Oh my God.
Because he was saying that the uncle lived there. I spoke with the mother, lived there. And I said, does this kind of look like him? He said, yeah, it kind of does. And then I started doing my search. So this is all based on me doing my searches and trying to figure out who was in my house, who was living in my house. So I didn't know who was living in my house. I just told our month with there and it's stumbling through the hall. I thought so. That's my footsteps. Yeah, they're washed. This is just what you call me. Oh, about
Here's not a question. You can have a seat. You may step down. Here's what I'm going to say. You filed this complaint for unspecified violation.
What'd you say, sir? I didn't hear that.
You filed this complaint for unspecified violation / fraud / misrepresentation of person in lease, which I believe those are two different things because you said you were dealing with somebody else and not Miss Lyman.
Yes, in the beginning, I was dealing with that lady in the back. Introduced herself as Joanne. That's who I was dealing with. She's her mother.
And persons in whole and non-payment of rent. Those are the 5 bases. I'm going to tell you, now just say this and I'll let you guys give whatever statement you want to regard. Violations of the lease are tenuous at best. Fraud and misrepresentation of the person in the lease, which is this other person. Ms. Lyman has been here when the court required her to be here. It's Ms. Lyman. The fraud, stop. The fraud, there would have to be some type of reliance on something, but that's not what you relied upon to rent. So that's tenuous at best. Other than somebody's speculation, which is actually hearsay based upon hearsay, because supposedly they're the persons that are telling you X, Y, and Z. I have nothing to say that there are other people in this home other than your statement. And it looks to me like the rent's paid. What I do, however, see, and I haven't come to a final decision on any of this, I'm just telling you where I'm at, is that there's been an interference with her quiet and useful enjoyment of the premises, and continues to be. And that there are potential damages for defamation, which relate to that quiet and peaceful enjoyment of the premises. So here's what I'm going to do. If you say you want to resolve it, then you need to resolve it. But I don't think, quite frankly, Miss Anderson, you're in a position to get everything that you want.
Okay, sir. Whatever.
So you just have to talk. I'm going to give you two a chance to go out and see if you can resolve it. If not, I'm going to come back in and I'm going to resolve it. And I'm going to tell you that somebody is going to be very, very unhappy. And I'm not saying anybody has to do anything. But I think if one looks at it, you can see where your strengths and weaknesses are. Now, if you want me to make the ruling, I'll make the ruling. I don't have a problem doing I can tell you with reference to the claim of the monthly visitation, not gonna happen. $750 is a curious question, but may have to be litigated another day. Because as I recall from the previous proceedings, you had agreed that it would be refundable. But now today you seem to be saying that it's not, or that you're placing on it impossible conditions.
It's refundable.
That would. Ms. Lyman, you politely raised your hand. What would you like to do?
I was just saying I wouldn't want to break off and talk to her. That's all.
Well, I'm gonna see if you two can talk to each other. And all you have to do is agree upon a number. I don't really care how you got there. You don't agree, you don't agree. I come back, I'll make the call. I don't have a problem. Okay? Court's gonna stand in recess, 20 minutes.
Right. It's just for kind of myself with this knowledge present. So coincidence.
Maybe seated. We're back on the record of the case of Anderson versus Lyman. Did you folks come to any agreement or no?
No.
No. Okay, very good. That's fair enough.
That's like what I had suggested.
No.
Oh,
And I say it that way because I didn't want to know what that process is because I've got to make a decision on it. So I don't want to know that. If there was an opportunity for you guys to address it, then you could have. And Ms. Lyman has indicated you didn't come to an agreement. Anything you want to say in regard to closing arguments, Miss? Yes.
yeah, I'm willing to waive.
There you go. Go ahead.
Huh? Sir?
Go ahead. This is closing argument. Go
Yeah,
ahead.
I told Miss Lyman that I was willing to waive the late fees, to waive the court costs, give her the $300 for refund of her security deposit. So I would only be asking for $3,000 for September rent, and then $143.93 for May water. I think that's fair, and I also hope I'd be willing to write a statement about this security deposit being refundable if it's in real stock condition. So I thought that was fair. So all I would be asking for is $3,143.93 for September rent and May water. And then $3,143.93. And that gives her the $300 credit we wanted to give her to the security deposit for September rent. That's waiving all late fees and waiving court costs. And so I'm at rent costs. And then I would be willing to sign something giving her security deposit back, as long as it's, clean, so I don't have to hire somebody.
Dealing with the security deposit. Fair.
That's
Lyman.
I feel that I should be compensated because she gave out my social security number and copies of my ID, which was attached to the email. A picture of my ID and my social was at the bottom. I feel that is defamation to my character, and it has the whole neighborhood in that email. I do not know them people at all, and my social is very, very sensitive information.
I did not give her social.
I feel that.
Ma'am, Ms. Lyman, hold on a moment. She did not interrupt you. Go ahead, Ms. Lyman.
I feel that the late fees are excessive by some compensation of the rent, probably at least half if possible. If not, that's fine. Just think, just some type of rent would be nice, just because I haven't been able to enjoy the home since moving in May. This rent, I feel like I owe $2,267 because I paid an extra $200 in June.
Hold on a second. You're arriving at that figure coupled with what you put into escrow?
Huh?
I'll let you finish. Go ahead.
I feel like I owe $2,267 for the month of September because back in June I paid an extra $200 and I moved in after May 1st. So $533 should have been prorated. I got that by dividing 3,300, then divided by the 31 days that's in the month of May, which came up to 106 and some decimal points. Then I times it by 5 and got $550. So that's how that prorated out. Then from the security deposit of the 300, I added all that together and got $1,033. So I did 3,300 take away $1,033 to get $2,267 for the month of September. Yeah. That's pretty much it. I just want to be able to enjoy the home without being bothered or anybody popping up or watching me.
Thank you, Ms. Long. Ms. Anderson.
Yes, sir. I wanted to clarify. Our tendency, our release goes the 5th. So what I explained, the reason why I didn't wait the first month, right out of bed and goes with it. She thinks that I should berate it. I just have to be on 50. That I didn't berate. And do so. Of the 4th, not the month. I was trying to explain that why I didn't berate it.
Well, thank you both very much. What I'm going to do is I'm going to go through these calculations, try to figure this out. There will be no additional argument or witnesses on the case. I will render a decision and I'll set it for October 14th.
Oh, I was just trying to I turn these photos into you?
I don't need them. I'm good.
Okay.
So, October 14th, 2025, 9. Yes, Ms. Sanders.
Can I get the 2 zip drives that I didn't include as evidence since they have Mabel's photos on them?
Ma'am, once I am done with the case, I will make a decision on that. I've told you that time and time and time again. But they were submitted to the court and I had yet heard the trial nor rendered decision on the trial. I will then make a decision.
Photos of my little boy.
Ma'am, what did I just say? Thank you.
Oh my. I forgot I was even live. It's almost 1 o'clock in the morning. Crazy, ladies and gentlemen. I got no business. Got no business enjoying that Judge Simpson with my great friends and this wonderful chat. And that was a hilarious chat. That was a frustrating case. It was an interesting case. I can't wait to see what I feel like we have some sort of Solomon splitting of the baby incoming. I don't know what that would look like in this case, But I just feel like that's, you know, just knowing Judge Simpson and how he handles these things, it'll be very down the middle. Nobody will be happy with whatever he comes up with as a solution. And that's why he always stresses to people so hard to work this stuff out. Talk together. Don't be like that. Ladies and gentlemen, I'm your lone wolf Usul. We're done here this evening. I've done all I can. I've shown all I can. And that's not even everything that happened today. We didn't even get to Judge Webster's sovereign citizen. Yeah, that happened. Watch for the video. It'll be out there. See you later. Have a great night. Thank you very much for hanging out. The chat was amazing. You're all great. Good night. Oh yeah, come by tomorrow around 8 o'clock, 8 p.m. Central Time, 9 p.m. Eastern Time. More daily docket action. Lone Wolf Usul and all of his friends. Y'all have a great evening now. See you later. Oh, and one last piece of business, ladies and gentlemen. I do have to say thank you very much to Old and Fat this evening for his 2 super chats. Thank you for the quick and great work on getting this day-long case condensed and viewable, and you're so welcome. It's what I do. I do it every single day. Come back and enjoy it with me. You were all fantastic. Thank you very much, ladies and gentlemen. You're wonderful. Have a great night.